Morning. Welcome to the Hingham Zoning Board of Appeals meeting. It is May 3rd, 2018, 7:15. First item on our agenda is Riverstone LLC. This is a continuation from our hearing on April 25th. Project is off Ward Street. Application for a comprehensive permit under Mass General Laws, Chapter 40B, to construct a 36-unit condominium development, including 9 affordable units, on approximately 6.7 acres of land located in Residence District B. The revised site layout plan, dated April 25th, 2018, depicts 32 units. If there are representatives from the applicant, please come forward and take a seat. Please just identify yourselves for the record.
Good evening. My name is Warren Baker. I'm counsel for the applicant, and with me is Brian Murphy, principal.
Thank you. Welcome. We will start with Emily, the zoning administrator, to review what has been received either at or subsequent to the prior meeting.
Okay.
And please speak up.
Sure.
And before you begin, if anyone has trouble hearing, please wave your hand and we'll do what we can to speak louder. And I should have said before we proceed that these meetings are being recorded by HCAM as well as by the zoning office.
Thanks. So since the last hearing, we have not received any materials submitted on behalf of the applicant. We've received some from representatives of either the board and or the town. These include a civil peer review, a comment letter from Patrick Brennan, PE, Amory Engineers, dated April 26, 2018. We received department comments from Lieutenant Chris DiNapoli, Fire Prevention Officer, including specifications for the new aerial apparatus that the fire department has ordered, dated April 26, 2018. Board of Health comments dated April 30th, 2018, responding to the hydrogeologic evaluation prepared by Peter Dillon and submitted by the applicant last week on April 25th. We also received a supplemental traffic peer review letter from Jeffrey Dirk, PE, PTOE, FITE of Vanessa and Associates, dated May 3rd, 2018. From abutters and or members of the public immediately following the last hearing, we received from attorney Jeff DeLisi on behalf of abutters an affidavit from attorney Edward V. Casey regarding ownership and rights in the 40-foot way at the end of Autumn Circle, and as well as the First Amendment to a verified complaint in the matter of Ann C. Mullen and Joyce A. Bethany, plaintiffs, the Viking Lane LLC and Riverstone LLC defendants. We also received comments from Arthur and Regina Casey, 17 Autumn Circle, dated 4/2018, that were forwarded actually during the last hearing on April 25th, 2018. Comments from Jean and Jean Silverio, 6 Autumn Circle, dated 5/2/2018, as well as an audio and video recording from Lisa Taylor of 16 Autumn Circle that was received this evening of the wildlife in the backyard.
Okay.
And that's it.
That's it. I want to confirm with Attorney Baker that, in fact, nothing has been submitted that we might have missed.
No, there isn't, and I hope I didn't misunderstand the last time we had a meeting that I don't think you wanted anything because until you had the conditions. As a matter of fact, there was a response from Mr. McKenzie to Amory Engineers. It was sent to him. I didn't give it to the board because of our discussion of last week. We will submit it, but it's more housekeeping, I think, than anything that would affect what you have done. But I did not want to submit it until. It's also 84 pages. So that is going to have to be emailed, but also hand-delivered. But I wanted to make sure that we got through this evening before anything else was submitted.
The purpose of this evening is, in fact, to review your proposed list of waivers and consider the conditions that staff has been working quite diligently on. And then I appreciate your your procedure so that you're not delaying that discussion. Before that discussion, though, I noted one of the new items that the zoning administrator mentioned is information that was submitted by Attorney Jeff DeLisi, and I'm wondering if you could just summarize that in, I'm going to say, 2 minutes or less, if that's possible, because while it's not the focus of this meeting, I want to make sure that it's part of the record.
Sure, you're asking a lawyer to summarize something in 2 minutes or less. So the two documents that were filed, one is an affidavit of Ed Casey. Ed Casey is a very qualified title examiner who has examined over 40,000 titles and has been an expert witness in innumerable cases before the land court. And he provided an affidavit that basically indicated that he reviewed the titles of the Mullins as well as Joyce Bethany, and that's 18 Autumn Circle and 23 Autumn Circle, my clients, as well as the title of the applicant and the project site here, and that he indicated that it was his opinion that there was not any common ownership, common title, and also that there was no instrument of record that he could find that indicated an affirmative grant of an easement or no reservation of an easement as well. And so his opinion was that that if there are any rights to the way, that those rights would be for the benefit of either the town or the people shown on the Autumn Circle subdivision plan, and not the applicant, Riverstone, or its predecessors. Additionally, the other document was a amended complaint, and as I indicated to the board and in a previous hearing, I would be filing that. I have now filed that document, and essentially I wanted it to be a matter of record because it was verified under oath. It does have some documents appended to it and plans appended to it. Essentially, it indicates, consistent with Mr. Casey's affidavit, that there is no instrument of record, no easement, in the title, no common ownership, and further it goes on to allege counts on behalf of both the Bethanys, or Joyce Bethany and the Mullins, for what's called a tri-title action, which essentially says somebody else has claimed an interest in my property. I shouldn't have to prove to the court that they don't have it. They should have to prove to the court that they do. That's one count. Another count was for an affirmative declaration that the applicant doesn't have any legal right to use the way. And then finally, there were counts that concerned in the alternative. In other words, in the alternative that there is a legal right to use the way, that it has nonetheless been extinguished by the concept or theory of adverse possession. We now know, for instance, that Miss Bethany's driveway is almost entirely located on the 20-foot portion of the way that is on her property, and so that's something that may or may not come into play. But I thought it was something the board should know and should have.
Thank you.
Yep.
So just to put this in perspective, you can sit down. I mean, this board is not going to be acting as a land court, but your lawsuit and the information you provided, I think, will be helpful as we fashion conditions. But again, we're not going to be presumed to be making title decisions here.
Understood.
Thank you. So before we proceed with considering waivers and conditions, I'll just ask if my fellow board members have any comments, questions, or concerns they want to raise at this point.
At this point, no.
Okay, great.
I think we should just
So with that,
get on with it.
there are two areas we're going to proceed in. First is considering the applicant's request for waivers, and then second, the conditions that staff has put together based upon input from this board, from members of the public, and from the applicant.
Other town board.
And correct, and other town boards, and our advisors, and a host of others. So with that, we have prepared our review of the requested waivers, and,
I don't think the applicant yet.
right, so I think I'd like to share with the applicant what I will call a staff draft. And the purpose of the draft is, in fact, to allow all of us to review it. So please don't think this is something that we've voted on or approved. It really is just a draft. And as we begin our discussion of the waivers, I want to remind myself, as well as my fellow board members, of what's provided in the Chapter 40B Handbook for zoning boards of appeal that was prepared by the Mass Housing Partnership and published in cooperation with the Mass Department of Housing and Community Development, Mass Housing, and Mass Development. Specifically, if I can find the right page, it's page 25, I believe. I'm just going to read it so that we know what our responsibility is and what the Department of Housing and Community Development has urged as the procedures we should follow. It begins at the bottom of page 25. Chapter 40B allows developers to request and zoning boards of appeals to grant waivers from local bylaws or ordinances and regulations. For zoning, the only waivers the development is required to identify are those involving requirements on an as-right development in the district where the site is located. I think I just might skip to the relevant section rather than keep going here. Once the developer and the zoning board agree on a proposed plan, including negotiated changes, if any, the zoning board should grant the waivers requested by the developer. It is the developer's responsibility to identify the waivers needed in order to build the project. As a rule, the zoning board should not grant what is commonly known as a plan waiver or a blanket waiver to accommodate conditions that may be apparent on the developer's plan but not specifically identified in a list of waivers requested by the developer. So there are many more portions that are included here, but I just want to make sure that the board, my fellow board members, are aware of what we've been advised to do by DHCD, is to really look specifically at the waivers as requested by the developer and not simply a blanket waiver that might be referenced by looking at the developer's plans. Susan, is there anything else specifically you want me to, you think would be appropriate to read from the handbook at this time?
The handbook's in the record.
Yep.
And you've read this, I believe you've read this once before, all of it. You know, the language goes on to talk about how it would be very difficult for the building official to apply and interpret the decision if the waiver list was not specific, and gives other reasons why it's not appropriate. So, you know, I believe you've covered it.
Okay. So with that, let's turn to the waiver list. Let me ask Emily the best way to proceed. Emily, do you want to guide us through this or have me read it? I'm just wondering about the most efficient way to get through these waivers.
I wonder whether the applicant might want to read their requests, and then we can go through staff recommendations, or would that be?
No, I think this
Yeah,
needs to
we'll
be
keep it on our
controlled
side?
by the board. We have their written requests.
Okay. I'm happy to
Yep.
give it a go.
Please.
We'll see how
Okay.
it works out. Okay. So the first waiver is from Section 3A 1.4 through 1.17 of the zoning bylaw. What the applicant has proposed are townhomes or multi-unit developments, and this use is prohibited in Residence District B. This is consistent with other 40B applications we've seen in the past, and staff has indicated that it would be okay to grant this waiver.
To allow for multi-unit development.
Right.
And I'm just going to ask if you differ from what staff has recommended, please say something so we...
Yep.
Okay, got it.
Okay so far.
Yep.
The next request is for a waiver of site plan review, particularly Sections 2, which are procedures, Section 3, pre-application submittal, Section 4, submittal requirements, items C, D, J, H, I, and J, Section 6, review standards and approval, and Section 7, lapse. In general, we've recommended conditions to address many of the particular waivers that they've requested here. There are actually some that, in fact, we don't believe the applicant needs. So maybe we can quickly flip to that section of the zoning bylaw.
Yep. So we're talking about, that's on page 7.
So I believe the applicant is suggesting that they need a waiver from procedures to allow the zoning board to act as the planning board on site plan review. I'm trying to interpret their request, and as a matter of law, that is not a waiver that they need. The zoning board is acting
We are
as the
acting as
planning board.
Right, so that would not be a waiver.
It's not it shouldn't have been requested and it doesn't need to be
So
granted.
that is with respect to procedures too. So I'd ask the applicant if there's anything else other than the name of the body that would be acting under site plan review that you're seeking a waiver.
Well,
It's
obviously,
just limited to Section 2. We'll go through the other
no,
subsections.
I appreciate that. The waivers that we have submitted was an expanded list in many ways based upon the understanding of what this board was requiring. I don't disagree with the fact that we don't need it.
Right.
But we basically heard that we needed to ask for the waiver. So there may be instances like this. I'm well aware that you're the planning board
Right.
under this set of circumstances, but because of the conversations we had, we included it to be on the safe side.
Okay, so if there was an impression that you needed waivers with respect to powers of various boards where the zoning board is in fact empowered under state law to act on those boards' behalf, such waivers really are not required. I just want to make sure that we are not missing something. So if we've got the gist, which is this was a safety issue to make sure that it's okay for the planning board not to be acting, we're fine with that.
Right.
Okay.
So,
And then 3, which is the pre-application submittal.
right, which will just, it actually starts off with applicants are invited to submit a pre-application sketch. It's not a requirement, and therefore I don't believe a waiver is needed.
Okay, again, I assume it was just a safety issue on the applicant's part, and I would note that the waiver is not required.
In Section 4, submittal requirements, the first item they're asking for a waiver of is Section C, which is a plan showing proposed circulation of traffic within the development and on adjacent ways, dimension plan of loading and parking areas, aisles, driveways. These are all details that their plan includes, and therefore I don't believe they need a waiver of this
And
requirement. They comply with it.
well, so I would, my view that we would not be granting that waiver, noting that the plan submitted to the zoning board instead of the planning board.
Item D is an analysis of compliance with all relevant dimensional provisions of this bylaw. I think by default, this waiver list is an analysis of the ones that they don't comply with, so,
Well, to put it differently, to the extent that they do not comply with certain dimensional provisions, and they have not included it in the analysis or in the specific waiver request, they would then not have satisfied the requirement of D. So that is a provision that we should not be waiving, because in fact, it's necessary for this board to do its job.
Item G is an analysis of the capacity of town soils, water supply, ways, and services to absorb the impact of the proposed development. We've received some material, others we've proposed conditions to require submittal of those documents.
So again, these are not items that we would be waiving.
Item H is an analysis of compliance with the most current versions of the Massachusetts Department of Environmental Protection Stormwater Management Policy and Standards and the Massachusetts Erosion Sediment and Control Guidelines. So we have conditions proposed to ensure compliance.
Okay, so we would not be waiving this.
We've actually discussed on several occasions a site lighting plan showing location, height, photometrics, orientation, and specifications for outdoor site lighting. The applicant has indicated they're not going to be providing that. We've suggested conditions to require submission of this information.
Right, and so I would be saying that we would not be waiving that. We specifically need site lighting plans to deal with, to the extent that there are safety concerns, if the light is intruding into sort of open space areas, to the extent that it may cause, traffic issues. All those things are legitimate concerns of this board, and I would say that we should not be waiving those.
I'd like to add that's information that we've received from other 40B applicants in the past and in the recent past.
Yep.
As a matter of fact, so. Okay.
And J is such other materials necessary to enable town boards to make a positive determination on the proposed development. So we've identified in the past other documents that this board would require that we've not yet received. And so while it's general, I guess we'd recommend against waiving.
So I guess the issue here is that the waiver would apply to the extent that it talks about enabling boards other than this board to make a positive determination, because only this board is acting. But otherwise, this provision should not be waived.
The item 6 under site plan review are review standards and approval. I guess it's not clear to me what particular provision under this they would like, unless it is, again, the difference between the planning board and the zoning board acting.
I guess, and Susan, I'd ask for your review on this. This particular provision talks about, let me make sure I'm looking at the right one, this is 6, talks about the issues that the planning board would be focused on, and to the extent that those issues go beyond the ones that 40B allows this board to consider, I want to make sure that we are limiting this board's actions to what is allowed under 40B.
Yeah, I agree with that statement. I'm just looking at what the language of this is. So, planning board approval shall be granted upon determination by the planning board, site plan approval, that the plan meets the objectives listed in this list.
Right.
I believe they are the same, the majority of them are the same issues that you're reviewing, but I don't know that you want to incorporate these review standards when you have the 40B review standards.
Right. So I would say that there would be a waiver of this
Yep.
to the extent that
Yep.
that it was inconsistent with what is allowed under 40B for
Right.
this board to
Yeah,
consider.
I agree.
Okay, good. Next is
And item
lapse.
7 is lapse, that the site plan approval shall lapse after 2 years from the grant thereof if substantial construction or use has not commenced sooner, except by good cause, which I think is consistent with the 40B timeframe as well. Is that?
2 years.
Right here, it's 2 years. So is there,
I will say, the first time I got the message, it said lapse. I'm thinking lapse like in a swimming pool when you're lapsing. That's not what we're talking about. It's like lapse in terms of it's lapse of time, exactly.
Yeah. I would say just that the statement should be, I think the regulations that govern, they're very specific about when the permit lapses.
Okay, so
So
again-
I would suggest that a waiver of this is not detrimental because you're subject to the lapse provisions of the regulations.
Okay, so this provision would be lapsed. In lieu thereof, we would have the lapse provisions provided under 40B.
Right.
Great, okay. Thank you.
Okay, so the next section of waivers relate to Section 4A of the zoning bylaw, the dimensional standards. The first, they're requesting a waiver of the 35-foot front yard setback required in Residence District B. They instead are requesting a 5.7-foot front yard setback that's specifically related to the decks, the rear decks of units 20 and 21, and then maybe a little bit less than that, but still relief for unit 19 as well. The office, to help you understand whether this would be an appropriate waiver, given the surrounding neighborhood context, had done an analysis of other properties along Ward Street, so that they're asking for relief for the setback from Ward Street. And what we found is that the average
Mr.
of
Baker.
all of the direct abutters
Pass that down.
on Ward Street for the front yard was actually greater than what Residence District B requires. Their setback on average 44 feet. And then the average of all, Ward Street abutters only, so just that side of the street, is in fact 51 feet. They're, again, proposing 5.7 feet. So staff has not recommended this waiver.
And Joe, I would make one other note that we have the zoning exemption chart that was submitted to the subsidizing agency for the project eligibility letter, and for front yard, side yard, and rear yard setback, they proposed 15 feet. But these plans are asking for 5.7 feet. In some locations.
Yes. It would seem that we clearly need to consider what's appropriate to protect the neighboring properties. And that is something that I believe is within our purview. So are we, at this point, going to recommend no waiver or a waiver of a different setback?
So
Or, I'm sorry, go ahead.
to the extent that all the surrounding neighborhood context, the setbacks actually exceed what Residence District B allows, we would recommend no waiver, and that they could build to the 35-foot front yard setback, which is still closer than it seems everybody else in the area has built to.
Yep. I mean, I think that's an appropriate standard. The bylaws, that standard is really what's appropriate. And when we look at site design, site concerns, and again, protecting the neighborhood properties, I think that's an appropriate position. What's in the bylaws should not be waived.
I would agree. I mean, it speaks more to maintaining the character of the streetscape in particular. So I would also be in favor of not granting this waiver.
Okay, so we're in agreement.
Next waiver they've requested from side yard setback, Residence District B requires 20 feet. They've identified a number of units, units 18, 19, 32, that are all proposed to be 10 feet from a side yard setback. And then units, 18, 19, 24 through 27, and 32 are all less than the required 20-foot setback, but not as close as 10 feet. Again, we did an analysis of the neighborhood to see what is typical and identify what the character of the area is. The average of all the Ward Street direct abutters for side yard setback for north side was 33 feet, south side 37 feet, for average of all Ward Street abutters, those within 300 feet. North side was 57 feet, south side 36 feet. So again, this is an instance where what has been built out in the neighborhood actually exceeds what Residence District B provides. We've recommended that the board consider a partial waiver, not for the dwelling units themselves, to hold the 20 feet for all the dwellings, but allow some limited relief for projections that exceed what our exemption is in the zoning bylaw for decks.
So how would that waiver read?
So we'd have to read the condition that it would be, but the waiver would have to say a partial waiver shall be granted to allow decks to extend up to 10 feet into
The side yard.
side yard setback.
And other than the decks, is there any other limitation that you think we should be considering?
Not that we've yet considered. I guess the one item that we can,
Yeah, I'm just going to ask you.
Good point.
they've not shown any, and so I don't know what the applicant's plan is for HVAC, condenser units. Those are considered structures in residential districts, so they need to comply with setbacks, and so I don't know what your plan was for those.
But to focus our activities, we are only looking at the waivers that they've requested.
Well,
They've not requested
right.
that waiver.
They have
And
not.
We can make various assumptions, but
They have not, and they've also, though we've pointed this one out several times, not requested any waivers for retaining walls that exceed 6 feet in height, which are also structures. We have a condition related to those, but if you don't grant the waiver, so that's something we'll,
right, when we get to that.
again, they haven't asked for
Okay.
it, so.
Okay, so what I'm hearing is, at this point, we would not be granting the requested waiver for setbacks, except for decks interior to the property, they could go 10 feet instead of the 20 feet. That seems reasonable.
Okay.
Yeah, I mean, but
Need to give some relief.
I think that's appropriate relief, but I think we need to maintain, again, for our concerns about our site concerns, building design, and open space, that we need to make sure that the setbacks are respected. So I'd agree. Okay, let's move on.
Their next request is for a waiver of the Residence District B rear yard setback of 20 feet. They're proposing 5.6 feet at a minimum for units 9, for Unit 9, but Units 1 through 9 are all less than 20 feet, just not as close as 5.6. Looking at the surrounding neighborhood, it appears that Ward Street actually has in general, very generous rear yard setbacks of approximately 150 feet. So we're recommending that the board uphold the 20-foot required rear yard setback, again, with some limited relief for decks to extend 10 feet from the dwelling unit.
Yep,
I think that's reasonable, yes.
I agree.
Yep.
The next waiver they've requested, again, relates to site plan review, section 4B6. They're asking, again, for the zoning board to act as the planning board, which you are already.
So, again, I would say that the waiver's not needed, but make it clear that the zoning board is acting as the planning board in this regard.
The next waiver relates to section 4B9 of the zoning bylaw. This is actually our front yard setback averaging exemption. They're not eligible for it, so the waiver's not needed. You don't need to ask for relief from an exemption that you can't benefit from, because again, the average of the adjoining properties is something much greater than 35 feet.
I just would ask counsel if there's something beyond what Emily's mentioned that you were seeking with respect to this particular waiver.
Not at first blush.
Okay,
Not right now.
thank you. Okay, then I agree we would deny it as simply not being needed.
The next waiver is from Section 4CB, which are our density provisions. They limit Residence District B properties from having more than one dwelling per lot. I think we'd recognize this is a townhouse development with multiple units per one single lot, so the waiver seems appropriate.
So I agree with your comment, subject to the final approved plans.
Right.
The next series of waivers is from Section 4E, the residential multi-unit development. Do you want to?
Yeah, I'll speak to this one, and it was part of what you didn't read. I can read from the regulation. The handbook just extrapolates off the regulation that special permit requirements do not require, they are not required to ask for waivers because they're not required to comply
Right.
with the special permit. So, the board can walk through them if you wish. I mean, I think there's conditions that are proposed. Is there a condition with respect to this distance between buildings? So there's certain aspects of multifamily dwelling that Emily referenced in drafting her conditions, just for kind of benchmarks of what might be appropriate. But as a general rule, under the regulations, they're not required to seek waivers from these. So I guess, we can ask Attorney Baker again as well.
I mean,
How do you want to handle them?
He's conveyed the message that this is more a belt and suspenders.
Yep,
Let's
okay.
make sure that we've got the waiver request in.
Yep.
But this board, I think, should comply with the procedures of 40B, which is that, in fact, you don't grant waivers because special permit requirements by state law don't apply.
Right.
So anything here that relates to Section 4E, we don't need to.
No.
We don't need to grant.
Right.
Oh, I didn't mean to speak for Attorney Baker, unless you think that I've mischaracterized.
You did well.
Okay, thank you. Okay.
Are we going to review this section?
So I see no reason to review the waiver requests.
Okay. Yeah, great. So
That jumps us to
it jumps us all the way to section
4.
5A, which are off-street parking regulations. They're asking for a reduction in the aisle width for 90-degree parking. They're proposing 20 feet for 90-degree parking. My understanding was actually that the most recent plan set addressed this issue, and I do, does anybody know? I thought you had widened the depth of the parking spaces to accommodate this?
I know we widened it.
Okay. But I guess the aisle width is still 20 feet behind it, so even if the space is
Correct.
longer.
Right.
This is not a recommended condition. The traffic peer reviewer has pointed out on a number of occasions that because the visitor parking spaces in particular would require guests to back into the interior roadways, and they're proposing just a 20-foot roadway, it would require multiple turns in close proximity to the main access point to the site. So we have conditions related to this. I don't think this waiver would be appropriate, but we do have conditions based on the traffic peer reviews
Right.
recommendations.
But from what I've heard from the testimony, there are real safety concerns and site concerns if we were to grant this waiver. So I agree that we would not be granting this waiver. You okay? Okay.
And then section 5C, they're requesting a waiver from our earth removal regulations. So again, we agree that a special permit would not be required under section 5C. But to the extent they've not identified how they otherwise would need relief from this section of the bylaw, we don't recommend granting the waiver.
And is there a general bylaw provision as well?
There is that they've not requested relief from, so our understanding therefore is that they would not be removing any soil from the town.
Okay. So we are agreeing that the special permit requirements are not applicable, because special permit requirements are not applicable. But the earth removal conditions, we will be examining when we get to conditions. Okay.
Okay, the next section of waivers are from the Hingham Wetland Regulations. The first of which is from Part 1, Purpose and Procedures, Section 3.0, Regulated Activities. They've indicated they need a waiver of Section 3.1, which they've summarized as any activity proposed or undertaken within a resource area as described in the Hingham Wetland Regulations 2.0.
For my edification, which
Yeah.
resource area would that be?
We don't really know because they've not provided any detail. This,
The wetlands regulations.
yeah, we'll read the text.
Because unless there's a bylaw-specific resource area that's in addition to those under the state wetlands protection,
I believe the buffer zones
not
are
aware.
regulated.
is a regulated resource area under the bylaw? Okay.
Yes.
Right, which is not under the state regulations.
Right.
Yep.
3.1.
Right, but, okay, so section 2.0 lists
Everything.
8 different types of resource areas.
Yep.
And so they're requesting a waiver from jurisdiction with respect to every kind of resource area. I get, that's the only way Emily and I were able to interpret
Yeah.
it, unless
Unless there's any
it was
detail
intended
that.
differently.
So would that include a vernal pool?
I have to read them.
I don't see vernal pool.
Yes.
Okay.
Item 5 includes vernal pools in the resource areas. And I think, what's the kind, is that an isolated wetland, or is that what's the wetland that's behind
just
the
a wetland
regular
resource.
wetland? So, oh, I'm sorry.
Thank you.
So there's the wetland, obviously, that's shown on the plans, and then there's the vernal pool referenced in Mr. Zimmer's
Yep.
peer review. I don't,
And that's just what
were there
we're
any other resource areas that you?
supposing. This feels a bit like a blanket waiver to the extent they've identified what they want relief from to some extent, but not how their proposed plan how it differs from what's being regulated.
Yep. So in the absence, I think, of the specificity that's required, I would not be in favor of a blanket waiver of the wetlands regulations here.
Right.
Okay, let's move on.
Section 3.2, they've summarized as any activity deemed by the commission as likely to have a significant or cumulative adverse effect upon resource areas as herein defined. It's not specified, it's not clear to me whether they're asking for relief because it references the commission as opposed to the zoning board. I think there are certain resources that the zoning board has suggested the project may have an adverse impact on. I don't know that you would want to waive this.
So I would say that for all of the section here, 3.2, 3.3, anything under the wetlands bylaw, to the extent that there's a request for a waiver, that it be the Conservation Commission that be acting on the local bylaw, that waiver is not necessary because this board is acting as the Conservation Commission, and there's not a waiver. And I've not seen or heard anything that would require this board or make it appropriate for this board to be waiving any particular provision of the local wetlands bylaw. Okay.
I agree. Yep.
Okay?
Okay.
So, do we need to cover 3.3?
That's 3.2, 3.3, what about the application fees?
Well, and then they're asking for a waiver of the local fees. We had a lot of discussion about this. We believe they are in front of you right now under the local regulation, and that their application filing fee to the zoning board, in essence, is 13.1.
Okay, so what I'm hearing is that to the extent they view this as a requirement to pay an additional application fee to the Conservation Commission for a review of the local bylaw, that in fact is not required, so that there's no waiver needed because that's in fact not happening. And more importantly, to the extent that there's a requirement to proceed with the Hingham Conservation Commission under the state wetland bylaws, there should be no implication that there's any waiver of fees or otherwise. Okay, so let's move on.
Part 2, performance standards for resource areas. They're asking for a waiver of section 19.1, which relates to land subject to flooding and bordering and isolated land subject to flooding and vernal pools. So in particular, section C, they're asking for a waiver of the term vernal pool. They're asking basically for a waiver of the 100-foot setback from a vernal pool. And we're not recommending.
Right, I mean, I think there's site concerns, health concerns here that would dictate that we should not be waiving.
Right.
We have
Environmental.
petitions proposed that will
Right.
go over it.
Yep.
Right.
Correct. Okay.
I got to say, Emily, you're doing a great job. This is
Really?
tough stuff, so thank you.
Thanks.
Keep going.
I'm sure it's scintillating for
Okay.
the audience as well.
They'd rather be watching the Avengers, I'm sure. Okay.
The next section on the top of page 6, item D, are the performance standards that, again, relate to, well, it's broad, and I don't believe they've indicated exactly how they vary from these performance standards.
So I'm going to interrupt you. So for
Yeah.
19.3, it's for the rest of page 6.
Mm-hmm.
Am I correct that the staff is recommending no waiver?
Correct.
And dealing with the performance standards, buffer zones, landscaping, filling, structures? I am in agreement unless I hear otherwise.
And I'll just put one caveat that there are conditions.
Right.
Right, so to the extent that we have...
That do actually grant some relief.
Yep.
Yeah. So in other words, there is not a waiver of the condition, of the requirement, but to the extent that we impose conditions in lieu of those. Right. In lieu of what otherwise would be required.
Right.
So in the absence of conditions, we are not waiving. Got it.
So is another, I'm just taking notes, is another way of saying that they're waived only to the extent of the conditions, or is
Or
that not
there is no waiver to the, unless and to the extent that this
Okay.
board proposes conditions that in fact act as a waiver, or as a partial waiver.
Okay. Okay.
And then again, the filing fee, same comment as before. Appendix B, the guide to permitting under the Wetlands Protection Act. Again, this is the fees
Under the bylaw.
under the bylaw, right? And it's the same position that we just talked about. So moving on to the Article 22.
So we're recommending, based on input from the conservation officer, a partial waiver here, and it will be covered by a condition that would allow some activity within 100
100 feet of the bordered
Yeah.
vegetated wetlands.
Yeah.
BVW, okay.
So we can review that in more detail.
So again, this would be, there would be a partial waiver only to the extent that this board adopts proposed conditions. Is that fair?
Yep, correct.
And then with respect to 2C, you're not recommending any waiver, is that correct?
Well, 2B would be the same as 2A.
Right.
And 2C, we're not recommending any waiver. You're correct.
That's for work within 100 feet of a potential vernal pool.
Correct.
So it's not a potential vernal pool, whether or not certified.
Right.
Okay. So we're talking about the 100-foot, the vernal pool protection zone. So
Correct.
I agree, there
Yeah,
not be a
John
waiver.
Zimmer said it was a vernal pool.
Yep.
Okay.
Vernal pool.
Section 5, authorization of commission to deny project. I don't it's not clear to me, I mean, again, the zoning board is acting as the Conservation Commission under the local regulations. So to the extent that you believe you may have the ability to deny the project, you may not want to waive this.
Well, but the language, if you read it,
Like deals with the wetlands.
talks about denying permission for removal, dredging, filling, or altering. So they're not saying denying the whole project.
Right.
But denying certain removal, dredging, filling, or altering.
Right.
So I,
Subject to the bylaw, right.
so I guess the question, is there conditions related to filling, dredging, well, there's not really dredging, but removal, filling, altering, right?
There are, but I think if you don't waive this, then you, acting as the commission, have the ability to
To impose
deny
appropriate.
or, yeah.
Right. So have they proposed specific dredging activities? Right, so a request for a waiver dealing with dredging when they have not requested dredging is not an appropriate waiver request. Are there any items that they've required that specifically fall within the Section 5 provision?
I mean, at least based on this excerpt from Section 5, it appears this is it just empowers the commission to do something. It's not a standard that they need relief from.
Okay, so
Unless,
okay.
do you
So-
read it that way?
So I agree that
Yeah.
to the extent that the Conservation Commission and this board acting as the Conservation Commission is empowered to deny if certain activity happens, we're not going to be waiving that. Agreed? Okay, good.
Section 7B, again, is fees.
So there are no additional fees required to be paid to the Conservation Commission with respect to filings under the local bylaw, because this board is acting as the Conservation Commission. This has nothing to do with any fees that may be required pursuant to filings under the state wetlands regulations. Okay.
Section 8, they've requested a waiver of the commission's ability to require the posting of a surety bond or other security. And this is not something that we believe the commission regularly requires, and we believe this waiver would be okay.
Yeah, and I think to the extent that there are financial issues in this regard, that probably
I mean,
state law would
Right.
apply to this.
And it feels a bit like it's just giving the commission the ability to require something. If we don't have a condition imposing it, you're not going to require one, to the best of my knowledge.
I don't know if on 40B we can.
No, and again, to the extent that the commission, it's not something regularly imposed on
Right.
unsubsidized projects,
Right.
then it wouldn't be appropriate to impose it here.
Okay, so I agree on a waiver here.
Okay.
Agree?
Yes.
Okay, I agree.
Yep.
Okay.
Now up to Board of Health.
Yeah. So the first waiver they've requested from the Board of Health, supplementary rules and regulations, are under Section 4, application requirements. They've asked for a waiver of item 2. This, again, requires an application fee to be paid at the time of submission of the application. In theory, they are before you now under the local regulations for that application. And so they've already paid a fee to this board.
Right. So, again, there's no waiver required because we are acting as the Board of Health with respect to local bylaw issues. And this is no comment on any procedures before the bylaw, before the Health Department or Board of Health with respect to any state law issues. Okay.
The next one is item
I'm
3.
sorry, so just to clarify, so the waiver as to local fees, but not any fees that might be required
So
pursuant to.
there is no
state
waiver
Title
as to
V.
local fees.
Right.
Right. And we're not, because they're before this board and they paid the fee, and there would be no waiver to the extent it applies to the Board of Health considering state law issues.
Right. I don't think we have the jurisdiction to do that anyway. So.
Right, exactly.
Right.
The next item is Section 4.3, that the applicant shall also deposit with the Health Department at the time of application the sum set forth in the board's schedule of fees. And we'll just take a quick peek at that. It seems to be the same request as item 2.
Where is the schedule of fees attached?
No, it's not.
Oh, shoot.
So I think the first is just that you have to pay a fee. The second request
the
is
specific
that
fees.
here's where you go to see what that fee is.
So
Is that-
again,
Yeah, okay.
Right.
sa-
Okay, I
the
thought
same
I had it.
response.
So
I
it's the
thought
same
I
response.
had it with me, but it's not attached to my
Okay.
copy.
Okay. Under section 4.8,
Right.
they've asked for a waiver from, that they've included an excerpt as project exceeds 7,500 gallons of sewage per day. I think this is the requirement that they submit a plant.
A plant permit. Yep.
And there is this is not a recommended waiver by the Board of Health, and we've proposed a condition related to this, but we can discuss. And I will just note that if there are specific questions, Susan Sarney from the Health Department is,
So I see in the notes,
and Lizzie Aldridge.
so I see in your notes, 9,900 gallons of sewage per day. Is that what you?
That's what the applicant has proposed for their 90-bedroom development. And the Board of Health regulations require that for a project of 7,500 gallons, that they submit a plant permit.
So I think my understanding is we're going to address this in the conditions. And so I would say that we would not be waiving unless there are specific conditions we propose that modify this. Okay.
Item 9 relates to all percolation test results and groundwater elevation observations shall be considered valid for 2 years. They're
Valid for the duration of the project.
well, their results that they've submitted to us are from 2005, three. So they already are much older than what would be required, and we have suggested conditions related to this. We're not recommending a waiver.
Okay, I agree.
Item 10X, any or all other data required by the town or Hingham Board of Health. I guess that's taken out of context. I'm not sure what that means.
Okay,
Bear
hold on
with
a
us.
second. 10X. Any and all other data required by the guidelines. The guidelines are defined as, sorry, Commonwealth of Massachusetts, DEQE, Division of Water Pollution Control, Design, Construction, Maintenance of Small Sewage Treatment Plant Facilities, January 1988. So those are the guidelines. So any and all other data required by the guidelines, Title V of the State Environmental Code, or the Town of Hingham Board of Health. ... If a plan has been submitted to the board and a change is later made, such change or modification shall be made by revision change and dated so that it can be, it's just a dating thing for the plan. So basically, they're asking to waive the requirement to submit any other data required by state guidelines, the Title V state code, or by the Board of Health.
So I don't think we're granting this waiver at all, and unless to the extent that it's deemed that they have to provide information to the Board of Health with respect to local bylaw compliance. And they would be
There's
providing it to this
also
board.
a recommended condition from the Board of Health on specific data that they would like to
Right.
have submitted.
Okay. So I think we're...
I agree, yep.
Okay.
The next waiver is from Section 411. Again, is that, in this case, it's that the Executive Health Director or the Board, if they determine that further information is needed before the application is deemed complete, then they can require additional testing.
So such additional testing as shall be required may be sieve analysis, hydrometer analysis, on-site permeability tests, and groundwater observation wells. So those are examples of the type of additional information that they might, there's a list of other types of information and studies that they might seek to require under this requirement.
So again, to the extent that there's a suggestion that the Board of Health or the Executive Health Officer acting independent of this board could make such a request in connection with local bylaw compliance, that needs to be corrected to make it clear that it would be this board or the board's agent, in this case, the zoning administrator, that could make that request only with respect to the local bylaw issues.
Right, but, and then there's also a condition proposed that specifies specific additional information that they're asking the board to require.
Right.
So I don't know.
That the Board of Health is asking the board to require.
The Board of Health is asking the zoning board to require the submission of certain reports in connection with the Title V
Right, so,
system.
right, so it's clear that it's this board that's making the
Yep.
request to the applicant, but in terms of the substance of what is going to be requested, there may be conditions associated with that that will be reviewed when we turn to the conditions. Okay?
Okay. The next waiver request is from section 412. It again is repeating the fee waivers, but in this case, it seems to be related specifically to peer review fees or fees to witness test results. These are fees that the other 40B applicants have supported. We've had test pits witnessed and
Is there a
whatnot.
condition related to this?
There are conditions related to the zoning board's continued inspections and/or review down the road. I don't know that there's one related to,
So, Susan,
review.
yeah, so it would seem to me that to the extent there's a waiver request here, it would not be appropriate to the extent that they're talking about the Board of Health making the request as opposed to the zoning board, and as to the specific either timing or amounts, there would only be a waiver to the extent that the 40B requirements of the state are inconsistent with what's in our bylaw. And if there's no inconsistency, there's no waiver.
Okay, so I'm not sure that I understand that. I guess the question is, in connection with certain plans and detailed plans, because the board's only received preliminary plans, that will need to be reviewed post-permit. There are conditions proposed with respect to that peer review or plan review, that peer review funds will be submitted. The question I guess I was asking is would it be, given that this is a request by, when they say by the board, they mean the Board of Health, for consultant fees, does the zoning board wish to include a condition that would require payment of peer review fees?
Peer review fees, to the extent such reviews are required, for purposes of complying with Board of Health local bylaw issues.
That are not waived
That are
by
not
the
waived.
board?
Right.
Yes.
Yes, so, yes, but there should be no implication that the request for fees is coming from the Board of Health, it's
Right.
coming from the zoning board.
yeah,
Okay. So that's a note for when you're going through the
yeah.
conditions.
And you're right, there is a condition, I think.
There is there, okay, we'll
I
see
believe
when
so.
we get to
Yeah,
it. There's-
okay.
I can't
Good.
keep
Yeah,
track of
sorry.
them all.
Okay. So the next section they've requested a waiver from is section 5, permit restrictions.
You
Yep.
can move the mic a little closer to you.
Sorry, I apologize. This section indicates that a permit will become void automatically and without further action or notice if the work under the permit's not completed within 12 months from the date of issuance of the permit. Further, that the permit issued can be revoked by the Board of Health after notice of the licensed disposal installer if conditions set forth in the application have changed, and that they can be extended at the discretion of the Board of Health. This is again an instance where it's not clear why the applicant is requesting the waiver, whether it's the issue between which board is acting,
Well,
or if
again-
it's a timing issue.
So,
that-
again, the which board issue, everyone's going to be tired of this. We are the Board of Health for
Yep.
purposes of 40B, so there's no waiver required. They don't have to go to the Board of Health on local bylaw issues.
But if it's a timing issue, it would be helpful to know, so that this doesn't appear to be a blanket waiver,
Right.
what time frame the applicant is proposing.
So, right, so in other words, the bylaw currently provides, it has a 12-month time limit. So does the applicant have a specific time limit that they're proposing, or is just waive it, period?
There's no particular time. They have limited in this one. We have 2 years to build by the regulations. That number is also told by litigation. I have some 40Bs where the SWIFT process has taken 7 to 10 years.
Yep.
So every aspect of challenging and litigating, et cetera. So to have a 1 year, you can't do anything until the absolute last minute, rather than try to get these things in a row. So that, it is a timing issue generally, yes.
Right, so again, what I'm hearing is the 12-month limit. I understand the concern, but I think this board's view would be that we would adhere to the 12-month limit, noting that state law may in fact allow the applicant to have certain extensions, but that if there's litigation extensions or whatever, but the validity of those extensions is not something before this board. That will be a matter of state law. So in my view, the waiver is not granted.
Okay. The next waiver request is from Section 6, Design Requirements, Section 6.3 specifically. They're asking to have greater than 200 feet, which is what the...
This is for the sewage disposal system?
Yes.
Okay.
Greater than 200 feet between the structure served by the system and the system. So they have indicated here to what extent their plan varies from that requirement. They're proposing 466 feet, greater than the 200. My understanding is that the Board of Health has granted some relief from this standard in the past.
466.
Not to that extent, no.
Not to that extent.
So what guidance can you give us in terms of what an appropriate... Are there health issues that we want to focus on to make sure that we're not doing anything to imperil local health?
And is that the subject of any suggested conditions that you might have shared with us?
So if you're talking about, it's typically 200 feet, maybe plus or minus 10%, is that what it is, or what?
Do we need to come up with
We've
a...
approved up to 219 feet in the past.
Okay, so 219 feet, so that's your 10%.
I'd just like to note, there's one standard for residential, and there's a different standard for non-residential, and there's a performance standard related to non-residential, so
So
there
are we-
has been, right, am I correct that, and sometimes the system is further away in the non-residential, but they have to make certain, that's how I'm reading it. For non,
There would have to be alarms on the system, that's what this is covering. So if
Okay.
the leaching field fails and it's in the way back, like 466 feet.
Right.
Without alarm systems, how would we know it's in failure? Nobody really goes back there. So that's why we have the 200-foot regulation imposed. It's for public health and public safety
Right.
of a failed septic system.
But in this case, there
be
are
other
residents that are
other
very
units right there,
close
yeah.
to it, and the homeowners association would be aware, right?
And the other thing to consider with this one is that there's a sewage collection system that brings the sewage from the units to the septic system. So it's not like a single-family home where you have a septic system out in the middle of the woods. This is right in the center of the development, and the sewage collection system is somewhat different from what you see on a residential, single-family residence.
Are we-
There may be like grinder pumps, because one might be down in the hole and have to get it up.
Do we have conditions associated with this?
We don't specifically, but I apologize. The Board of Health had recommended in February that the ZBA require the installation of the alarm system and a maintenance plan to properly notify inhabitants of any failure.
So those would be conditions that we would be adding, and so...
The grant of a waiver.
Right, so I guess where I'm coming at is there is not a waiver unless, and only to the extent that this board adopts conditions that would facilitate such a waiver. Right.
Okay. Okay. The next section is section 6.5, that Interesting. That no sewage disposal system or plant shall be constructed within 100 feet of the normal annual high water level of any great pond, brook, river, swamp, or wetland. Do they need this?
Yeah, are we just talking
They're
about
not
the
within
soil
100
absorption system?
Yeah.
Yeah, I don't believe they need this one.
We're not, and this actually has been added since the Board of Health reviewed the waiver list, but I don't think it's
So
necessary.
I would ask council if you're aware that there's a specific need for this waiver?
Not without talking to the engineer.
Okay, so at this point, as the record stands, we would not approve this waiver because there's been no demonstrated need for it.
Okay. The next one is section 6.6, that no sewage disposal system or plant shall be constructed.
Emily, you're starting to fade in
I
volume.
apologize. Within 400 feet of a public water supply well or well field as defined under the Massachusetts Drinking Water Regulation, or surface water supply. They're asking for a waiver. They've not identified how their plan differs from this requirement.
Hold on a second, but it's not, they didn't, which one are we on?
Item
4.
6?
Oh, yeah, you got to keep going, because it says private potable well, or 200 feet, I don't know
Or
if they
100
are or
feet of
not.
any private non-potable
Or
well.
250 feet from a private potable, or 100 feet from any private non-potable. So I don't personally know whether or not they're within these distances of any of them.
I don't
I
know.
do not believe they are.
They believe they need this waiver.
Yeah, so, and particularly, I mean, this raises some serious health issues, so I would not be inclined to be in favor of this waiver, and I've seen no
Correct.
demonstration by the applicant that we should be considering.
Okay. The next one is section 6.7, that no leaching facility shall be constructed within 25 feet of any surface or subsurface drain where the drain elevation is higher than the proposed leaching facility.
So let me just stop you for each of these. We've got A,
Yep.
B, C, and D. Is there a demonstration that the applicant needs these waivers?
No, I don't believe so.
I believe for A, there is, because there's catch basins just down gradient from, actually right at the edge of the system.
Right.
In the roadway, so they would need from A for the catch basins.
And do we have conditions on that one?
No.
Is this the case, too, that the drain elevation is higher than the leaching field? I don't know if that refers to the inlet or the outlet, or...
We don't have any information on what the bottom of the leaching field is set at. We have rim elevation of the catch basin, but we don't know where the septic system, soil absorption system.
We don't know what the elevation of the proposed leaching facility is?
That's correct.
So there's no demonstration that they need it, since this requires us to compare two elevations, and we only have one. So I'm not sure why we would be granting such a waiver.
Right.
Yep.
So I think the answer is for A, B, C, and D, without reading them all, that we would not be
Yep.
granting the waivers, and there's been no demonstration that the waiver is required.
Okay. Section 6.8, they've asked for a waiver from the Board of Health requirement that they not discharge, it's basically the 12.5 rule. They not discharge more than 110 gallons of design flow per day per 12,500 square feet in lot area. The Board of Health's recommendation on this has been that the applicant be held, that the board might consider a partial waiver, that some relief could be granted from this, but that the applicant should be held to a 10,000 square foot lot area per 110 gallons of design flow per day.
So the waiver would maintain the 110 gallons, but change it from 12.5 to 10,000.
In particular because of their concerns about nitrogen in relation to the potable wells in the area.
So by decreasing the square footage, there was less square footage associated with the emissions. So that would be a partial waiver. Your thoughts? And this is what the Board of Health is recommending?
That is a Board of Health recommendation.
I guess I could go with that. I mean, I know we had a lot of testimony on the potential for nitrogen here, discharges, and the valid local issue in my mind.
I think you can ask, Susan Sarni can clarify, but my understanding was when they presented that whole analysis and in their letter, they did it assuming a reduction of that, a partial waiver to 10,000, and that they found that to then
Yep.
bring the system into the 5. Is it milligram, is that right?
Yeah,
So is that a fair summary of what you said? And that was using a 10,000 rather than the 12.5?
State uses,
Right.
5 uses the 10,000
Okay.
square foot model for nitrogen-sensitive areas.
Correct.
We have 12.5 for the whole entire town.
Oh, sorry.
Okay, so we'll make sure people use the mic, but we're just trying to facilitate the flow here. So what I'm hearing is that this is an example where we are sort of balancing the health needs with the regional need for regional need for affordable housing, and coming up with an appropriate waiver here, which would waive the requirement from 110 gallons of design flow per day per 12,500 square feet to 110 gallons of design flow per day per 10,000 square feet in lot area. So that would be the waiver that I'd be prepared to recommend.
Okay.
Okay. The next one is Section 6.9, and this relates to the separation between the bottom of the leaching facility, right? Am I reading this right? This one, I may ask Pat to step in. The comments we had from the Board of Health on this specific waiver request were that the applicant has not met the state Title V standard and demonstrated adequate percolation rates in the most restrictive area and spaced uniformly over the proposed soil absorption area and proposed reserve area regardless of the rates imposed.
So they're coming out no waiver here, is that correct?
So Title V requires either a 4-foot or a 5-foot separation from groundwater to the bottom of your septic system. That's based on the perk rate of the soil. The local regulations add an extra foot to that. I believe that's what the waiver is from, is adding that extra foot.
Right.
So complying with the local reg instead of, but again, they haven't told us what the bottom of that septic system is going to be, so we don't know what the separation is at this point.
Okay, so there's been an absence of a demonstration for a need for this waiver. So I propose we deny it.
The next one is Section 6.10, that the applicant has proposed to use the area between the trenches and the leaching field as part of their reserve area. And this is something that the Board of Health has said that they would be comfortable with the board waiving.
So again, this is where health concerns are being looked at by the Board of Health, and they've made the recommendation, and this board, weighing the need for affordable housing and health concerns, are prepared to recommend a waiver.
Yes.
Okay, so this one, which is sub 10, we would be waiving.
Okay. Next, they've asked for relief from Section 6.14, that the bottom of the cellar...
Aren't we at 12A?
Yeah, I think
Oh,
we're...
I'm sorry, did I skip one?
Yes.
Bottom of page.
Unintentional, sorry, 12A, where at least 5 feet of the underlying naturally occurring pervious strata is above the maximum groundwater elevation, except that at least 6 feet, okay. So they're asking for 5 feet instead of, is this the same as the last one, Pat? I apologize.
It's pretty much the same
Okay.
requirement. Title V requires 4 feet, and your local regulation requires 5.
But we don't know how they vary from it, because they haven't provided the information? Is that-
I believe that they have the 4, based on the old test hole data, so it depends on whether or not they're going to provide new test holes. But based on the old test hole data, they do have what they need out there.
So you're saying the
They-
waiver's not required because they've got it?
That's correct.
Under the bylaw, right.
No,
Correct,
they have the
yes.
4 feet or they have the 5
I
feet?
believe they have the 5 feet based on the information that's been provided.
Okay.
Okay, so we're not doing a waiver here.
Not needed.
Okay, now we're on 14. The bottom of the cellar floor must be at least 18 inches above the maximum groundwater elevation. I mean, this may be similar in that we don't know how they would vary from this, but the Board of Health had indicated that the zoning board could require adequate waterproofing and appropriate drainage system beneath the dwellings to protect against groundwater infiltration if the board chooses not to impose this
Are we
standard.
proposing cellars here? I thought this was...
Yeah, they
There
are.
are cellars?
Yep.
But again, are we clear that this waiver is even required at this
No,
point?
Pat, are you?
So in the absence of that,
Yeah, I'm not sure.
okay, so then I would not be in favor of granting the waiver.
Right.
Okay. Item 17, they're asking for 6 inches of stone where the local regulations require 8 inches in the leaching area beneath the bottom of the distribution lines. The Board of Health had said the applicant's required to provide plans to scale, specifications, and data to the Board of Health to determine if the proposed septic system is compliant. Submitted plans appear inadequate relative to this requirement. This may be a case where, yeah, I mean, these comments, the Board of Health comments on the waiver list were a little bit older, so potentially they've since provided that information.
Yeah, they don't show it on the 40B plans.
Right.
In the analysis that they did for the fire truck loading,
Right.
they said there's going to be 2 feet of stone underneath the pipes, so they don't need that
So they
waiver.
don't need the waiver.
Okay, so I would say we're denying that waiver request as unnecessary.
Okay, 18, they're asking that the Ts and the Ys, is that pronounced Ys? Connections be permitted in leaching areas where our local regulations would prohibit. The Board of Health, again, was indicating that they didn't have sufficient information to act on that one. I don't know that, any recommendations, Pat?
Just based on the conceptual layout, they are using Ts because it's a pumped system. So it comes out of the pump chamber and goes, but I don't know if it's a pressure system or if it's a gravity system. If it's a gravity system, they should not need Ts. If it's a pressure system, they will need Ts. We don't know what it is at this point.
So-
They still have to pump up, but there's 2 ways of doing that. You can pump up to a distribution box and it can flow up by gravity, or you can pump into the system itself.
Right.
In which way that is, we don't know right now, correct?
Okay,
So, but my question, is this allowed by Title V, Ts and Ys?
Yes, it is.
I think we should grant that.
Is there a health reason
Yeah.
that we should be considering that it should not be allowed in Hingham even though it's otherwise allowed?
I'm not aware of a health reason for it. Like I said, if it's a pressure pressure dose system, they need the Ts, because it's part of the manifold system that doses that soil absorption system.
Would there be any special conditions we would need if in fact they were going to be having Ts?
I don't believe so, because I think it's covered under Title V, because if it's not pressure dosed,
Okay.
each line has to come out separately from a distribution box, so there wouldn't be any Ts at that point.
Right. So what I'm hearing is there'd be a waiver on this?
Yes.
Okay, I agree. Okay, yep. So the waiver is limited to the local bylaw, okay. Yep.
Okay, section 622, they've asked for a waiver of the requirement that a new sewage disposal system or plant must be constructed prior to the commencement of the construction of a structure that it would serve. And the Board of Health had indicated that they expect the applicant to protect the soil from compaction before, during, and at conclusion of construction of all structures if the board does waive this requirement.
So am I correct that if there's a waiver, we could still
Impose.
protect the health concerns through appropriate conditions? Is that what I'm hearing?
That sound fair?
Pat, does that sound right?
Yeah, I believe so.
Okay, so then then we would waive, but only to the extent that the board adopts appropriate conditions, protect the health and safety of the community.
Ms. Jumbo?
Next one?
Next one, sorry. Section 5.
Oh, Section 7?
Section 7, wastewater treatment plant, they're just asking for a waiver of all of the requirements in that section. And their justification says that wastewater treatment plant, if required to be permitted under Mass DEP environmental code, so they're saying they're going to comply with Title V and not build a plant.
But do we have any reasons why they cannot comply with the local regulations?
Well, not
I
that I'm-
haven't seen it, that's what I'm
Yeah.
asking.
Yeah, not that I'm aware of. They've not proposed a plan.
So, again, in the absence of the applicant demonstrating a need for the waiver, I'm not sure why this board should be granting a waiver. So I would be,
Might dive into it and end up needing a treatment plan.
yeah.
Right. Right.
So I'd say we are.
I would agree with that.
Not in favor of that.
Right.
Okay.
Have we, then under here, you also have a 5 and 6. What are those comments? I'm confused.
So these aren't ours. This is the applicant's list. Only the red comments are staff comments.
Okay.
But they've requested a waiver from, well, I guess this is their number 5. It's their overall.
Okay.
Well, I don't.
Right.
Yeah, so they just didn't bold it. It's
So
just
any
different
fee,
format.
any bylaw fees other than what's required under the comprehensive permit
Yeah.
application? Right. Okay.
Yeah, so the zoning board doesn't generally waive fee submissions for, say, anything else that's required outside of your comprehensive permit. So to the extent that you are already acting as a local board
Right.
through this permitting process, they've already paid their fee. But after this process, if they have to pay fees under, to the local Conservation Commission or Board of Health under state regulations or the building commissioner, the zoning board has not routinely waived those requirements.
Okay, so I agree. So we are not granting the waiver, but we're making it clear that to the extent that they are before this board, as we act as the local boards under local regulations, no additional fees other than what this board requires, consistent with 40B, would be required.
Right.
And then the last item is that the project shall be exempt from any other applicable zoning or related municipal ordinances, bylaws, so far as the same may be at variance with the project or the site development plans or the architectural plans as filed, and this is specifically not recommended by the 40B handbook that you
Right.
read.
So this is in fact the blanket waiver request
Right.
that we would
Yeah.
not approve. But I note, Susan, that it's appropriate for the board to mention that we would entertain a request for minor modifications of the comprehensive permit if additional waivers are required, but as long as those waivers are substantially consistent with the approved plans.
Right, so generally, what the board does, and there's actually a condition, I believe,
Yep.
proposed, which states if it's not expressly waived, it's not waived, and that a modification will be entertained pursuant to the modification provisions of the 40B regs, in which you determine whether or not they're substantial or insubstantial,
Right. Okay.
unsubstantial.
So with that, believe it or not, we have concluded our review of the waiver request. That's only Part A.
Yeah.
Now we're going to do Part B, which is the conditions that we're going to impose.
Could you
And,
pass these down to the applicant?
We have these 2 extra copies.
Those are 2 extra copies for the applicant.
Get those to,
Do you want a copy? Anybody? Joe, I have a few others, if anybody in the audience want
I'd rather not.
Okay.
I think Jeff DeLisi.
What we, let's not
Okay.
do that now. So then we should review the proposed conditions. I will ask, as a courtesy to the applicant, if you need to take a 5-minute break for any reason before we begin Part B, or should we just move
We don't.
on? Okay, good. Okay. So now let's consider the proposed conditions.
Okay. So we'll just note, this draft had been started for the last hearing, and then we just, neither Emily or I noticed that we didn't update them, so the draft says for 4/25 hearing, but it's for the 5/3/18
Yep.
hearing.
Oops.
We don't even have the right year on there, just. the note.
2017, yes.
Yes.
Healthy dinner I'm having.
Really.
Okay. So this should properly be labeled a draft, and it is a staff draft for the May 3rd, 2018 hearing. If you could correct your copy, council, so that we make sure we've got the right date on it, 5/3/18. Okay, then you've got two preliminary comments or notes. The first is these conditions are in draft form, have not been reviewed by the zoning board, and that's the purpose of the meeting this evening. And then the second note, we should definitions to be included in the body of any proposed decision, which is the term project plans and the terms approved plans. We're not, I don't think we need to read that as long as the applicant sees it. So let's start with the proposed conditions. And Emily, if you could explain, it says attachment B.
Yeah, so we're envisioning how the whole decision ultimately fits together. So
Okay.
usually you have the body of the decision,
Right.
and then attachment A is the list of project plans, and attachment
Okay.
B has historically been the conditions.
So then we start with the general conditions. And I'm just wondering the best way to proceed, whether we read each condition, or how would you recommend,
Yeah.
so that we don't
17 pages.
kill the time here,
Yeah.
and we make sure that we cover the substance?
We probably want to read each one, but there doesn't, a lot of them are fairly standard, and there probably won't be substantive discussion about them.
So,
I'm talking about A, the general
right,
conditions.
so, I mean, if you, on the more general ones, I mean, we just summarize them. There's ones that are more substantive as to potential changes in the plan.
Right.
So for example, one is just kind of the general stating that it's a proposed, it's a permits a multifamily
Yep.
rental housing development, et cetera.
Oh, it's not rental, though. Sorry, that was our first typo.
First comment.
Oh,
Yeah.
Good catch, okay.
But again, this
So
is all.
that should be multifamily
This is
ownership,
all,
okay?
draft, it's going to obviously go out there, it'll be available
Right.
for anyone's review, so this isn't, the board is not voting on a project.
Right, but I want to make
So-
sure we effectively
Yep.
communicate to the applicant what the conditions are. So I think they've seen the general conditions, which are, we've got a multifamily ownership housing development, and obviously the applicant's going to have to record the decision with the Board, Plymouth County Registry of Deeds, and that sort of the binding nature of these conditions. I think we can move on from that. A requirement to keep the zoning administrator and the building commissioner copied on important correspondence, and they have to comply with all local rules and regulations in effect as of the date of the application, unless expressly waived.
So why don't you read this one?
It's 5 or 6?
5.
5, so the applicant shall comply with all local rules and regulations of the town of Hingham and its boards and commissions in effect as of the date of the application, unless expressly waived in what will ultimately be an attachment to the decision. That attachment will be incorporated into the comprehensive permit by reference and made a substantive part of these conditions. And then, with respect to peer review funds, the applicant shall provide peer review funds as specified by this decision. Any surplus funds remaining in a specific peer review fund may be utilized by the board for other peer review expenses as necessary as determined by the zoning administrator. Any excess funds will be returned to the applicant upon project completion. Then we turn to the general pre-construction conditions. Do you think it's needed to review to read into the record each one, or are there highlights?
Probably not. The first is really just that the applicant engage someone who will certify at project completion that everything's been built in compliance with the approved plans. Next, there's a pre-construction meeting requirement. Item 3, there is something that's a little more particular to this project.
I'll read it. Prior to the start of construction, the applicant shall submit the proposed transportation route for construction vehicles and material deliveries. Construction vehicles and delivery trucks will be prohibited from traveling on Autumn Circle. Said prohibition shall be included in all contracts for construction activities associated with the project. Material suppliers shall be directed to use the Ward Street access to the project. Okay? And they have to submit a construction schedule, and they need to erect, before they begin work, they need to erect construction fencing along all property lines, and supplemental construction fencing may be required by the zoning administrator as necessary to adequately screen the construction site from abutters. Number 6, we have the applicant to provide the zoning administrator with up to, and I see the $10,000 to support consultant review. I assume the word "of" is supposed to be there, of the project plan to confirm compliance with the conditions of the comprehensive permit. And such additional peer review funds as may be determined to be necessary by the zoning administrator in accordance with this particular condition. And the condition is not a limitation on applicants' other peer review expenses that may be required by this comprehensive permit decision. And next, the applicant provide the zoning administrator with up to $8,000 to support construction inspections of the project infrastructure improvements, including but not limited to installment of staked limits of work and erosion controls, clearing, grubbing, and subgrade drainage, roadway, fill, and foundation, and a final inspection. Moving on, we've got project-specific pre-construction conditions. And these are applicable prior to the application for a building permit. First is modification to project plans. Again, Emily, I'll ask if you think we need to read this in its entirety.
No, we don't need to.
You need to call out?
I don't think we need to read one. It really just identifies the procedures for filing the final plans,
Yep.
but we probably should read each of the subsets.
So the project plan shall be modified as follows. The building layout. Minimum front yard setbacks of not less than 35 feet measured between the Ward Street layout and any portion of a dwelling unit, including decks and porches. 2, minimum side and rear yard setbacks of not less than 20 feet measured between side and rear property lines and a dwelling unit. Decks and porches, inclusive of any stairs, may extend up to 10 feet into the required side and rear yard setback for a minimum side and rear yard setback of 10 feet for these attached accessory structures. Separation distance between buildings shall be increased to 20 feet. I assume that increase is from what's otherwise shown on
So
the plan.
this is one that the board didn't go over because the separation between buildings is
Yep.
a special permit multifamily. Sorry, I don't know which microphone I should be using. So I just wanted to call it out that it's not one the board previously looked at in detail. So I don't know, Emily, if you wanted to, or Pat can speak to the issues of distances between buildings.
They vary, but they had proposed, I think, a minimum of 9.88, if I'm reading this smaller plan correctly, 12 to 11 feet in other areas. It seems inconsistent with the neighborhood. There are some public safety concerns with the proximity of the houses to one another. The planning board had specifically recommended that instead of looking to the multifamily residential standard in that special permit section of 35 feet, that the board impose a separation of 20 feet between buildings.
Yep, okay. So we've just done, that's the bottom of page 3. Now we're up to 4 buildings, including units 22 to 23 and units 19 to 21, shall be oriented to present a front facade to Ward Street in order to maintain the streetscape. And then we have, one second here before I go on. So now we've covered the building layout. Before I go on, any comments, Mario or Joe, on up to now? Okay. Keep going then to the wetland resource area protections. The applicant shall delineate the limits of the vernal pool habitat within the bordering vegetated wetland and depict the limits and associated 100-foot vernal pool protection zone on the revised project plans. Second, all improvements, including but not limited to buildings, decks, and components of the stormwater management system shall be located outside the 100-foot vernal pool protection zone associated with the on-site vernal pool. 3, the undisturbed portion of the 50-foot wetland buffer zone shown on the approved plans as the existing tree line, and that's, see legend on sheet G1 for symbology, shall serve as the limit of work and identified on the grounds with monuments. No clearing, grading, or construction shall be shown on the final project plans or permitted within the area, with this area. 4, all construction proposed within the disturbed portion of the 50-foot wetland buffer zone shown on the approved plans as outside the existing tree line shall be mitigated by native plantings at a ratio of 2:1 or greater within the 50-foot buffer zone. And then 5, the applicant shall submit a spill prevention, control, and countermeasure plan documenting the procedures to be implemented during construction to prevent and address spills of hazardous materials within the property. Then we turn to C.
Hang on one second.
Yeah, sure.
I just want to go back to B1 there, the first one. It says bordering vegetated wetland. I'm not sure if that's correct. That might be the isolated vegetated wetland. Can we just check the language on that? In the wetland, or just take out the word bordering, vegetated wetland would cover it.
It is called bordering vegetated wetland on the plans.
Okay. And
That's
it's
what it's called.
identified, and that's where the vernal pool has been identified by our wetland subconsultant?
Yeah.
If that's the case, then, okay.
So the
fine, then
vernal
I'm
pool
fine with
is
the
within
wording.
the border, okay. got
Then
it.
I'm fine with the wording, right. Yes.
But I think it's important to note that we are proceeding based upon the applicant's representation as stated in the plans that we're talking about
Okay.
bordering vegetated
For
wetlands.
the record, I'm fine with the wording as
Good.
as we've read. So.
Can I have a suggestion that the vernal pool habitat has been identified by the board's peer review engineer? So, if the applicant shall delineate the limits of a vernal pool habitat, I don't believe, unless I've missed it, that they've accepted or acknowledged that. So do you want wording in here as identified by the town's peer review engineer? Because as opposed to
Right.
them coming back and saying, well, there is none for us to show on the plan.
Yes, good suggestion.
Yes.
Scientist.
Is what- At Wetland Sciences, thank you.
If you could just stand up to the mic.
Jeff Delisi. I have Bob Mullen with me. Bob's house is in very close proximity to this area of the vernal pool, and I understand that the vernal pool that is being talked about has not been certified. I thought that the board, and I'll leave it to the discretion of the board as to when, but Mr. Mullen can share with you his observations as to what he's seen out there as well.
I think we have a record right
Yeah,
now.
I mean, our wetland scientist said it was a vernal pool, so it's a vernal pool.
Right.
But I would encourage you, if you've got additional information that you'd like to submit, to make sure that,
Found amphibian, stuff like that.
Exactly.
right, so
As
if,
opposed to, whatever, we talked about them looking at that April, May.
Right.
Yeah, submit that to the board.
Oh, and I'm sorry, I might have not noted at the beginning that we, this evening, received a video and audio recording
mentioned
from,
that.
I did, okay, I'm sorry, I can't remember.
well, complete your thought, just to make sure.
I'm
that-
sorry, that it's related in part to the vernal pool, that the video and audio records the noises and sounds presumably associated with the vernal pool from neighboring property.
Okay, and so, again, to the extent,
there are-
yep, if you'd like to submit anything else, please, because,
Yeah.
Excuse me, I'm Bob Muller, I'm 18 Autumn Circle, but Mario said the town acknowledges it is a vernal pool. That's what I was curious.
Okay.
I might add that the spring peepers were probably pretty loud the last 2 nights.
I have earplugs and stuff.
Okay, we're up to C, internal roadway, pedestrian, and parking improvements. 1, all internal roadways shall provide a traveled way of 24 feet in width in order to accommodate, 1, the turning and maneuvering requirements of emergency vehicles, 2, parking maneuvers, 2, from the visitor parking areas, and 3, occasional on-street parking, particularly in the vicinity of Ward Street where parents may park while waiting for the school bus. 2, all internal roadways shall include a sidewalk along at least one side. 3, all sidewalks and pedestrian routes required in the comprehensive permit shall comply with applicable requirements of the State Architectural Access Board and Federal Americans with Disability Act regulations. And 4, vertical granite curbing shall be installed along the edge of the internal roadways adjacent to sidewalks. 5, 2 means of access to the project with sufficient width and grades to accommodate pedestrian and subdivision and safety standards are required. 6, fire truck turning analysis shall confirm that no portion of the fire truck design vehicle crosses the sidewalk area or extends into individual driveways in order to circulate the internal roadways. I just want to make sure that we've got this right, that we are requiring the applicant to submit fire truck turning analysis that confirms this. Okay. And then 7, driveways to individual units shall be a minimum of 21 feet long, measured between the garage door and the far edge of the sidewalk, edge closest to dwelling unit where a sidewalk is provided, and 23 feet measured between the garage door and the edge of the traveled way in locations without a sidewalk. 8, site distance requirements. The object height and the driver eye height shall both be set at 3.5 feet above the pavement surface. This revision will increase the line of sight that is shown and reduce the extent of the regrading that is required. 2, given that sight line to the west from Road C will cross the ground surface and not an area that will be cleared during a snowstorm, the ground surface shall be established a minimum of 1 foot below the sight line elevation in order to allow for snow accumulation. 3, the stopping sight distance along Ward Street approaching Road C and along Road C approaching Road D shall be provided in both plan and profile view. The stopping sight distances the stopping sight distance is required in order to demonstrate that a motorist traveling along Ward Street and Road C, assumed eye height of 3.5 feet above the pavement surface, can see an object established as 2 feet above the pavement surface. In the roadways at the intersections, a grade correction factor shall be applied to the calculated stopping sight distance requirements for Road C, approaching Road D based on an 8% grade along Road C. 10, fire department access into and out of the property shall comply with 52 CMR Section 1, that's the 2015 edition, as follows. 1, fire department access roads must extend to within 50 feet of an exterior access door for any dwelling unit in the project. 2, the gradient of any fire department access road shall not exceed 10%. 3, no obstructions, including but not limited to parked vehicles, shall affect any portion of the minimum width for any fire department access roads. And 4, fire department access roads shall comply with a vertical clearance of 13.6 feet.
I guess I just have a question on the wording of, is it 10?
Yep.
I don't know, I haven't looked at myself, because these recommendations came from the fire prevention officer who happens not to be here tonight. Shall comply with 527 CMR 1.0. I don't know if these are the only requirements of that. They're required to comply with state laws and regulations regardless.
Right.
I know that these are ones of particular concern, but I might suggest including without limitation.
Right. Good.
Because I don't think we should suggest that the zoning board is limiting the extent they have to comply with state law.
I agree.
Right.
Yep.
Okay, so 10 should begin. Fire department access into and out of the property shall comply with all state law requirements and regulations, including but not limited to 527 CMR Section 1. Any other
Well-
comment?
Well, are you keeping in the as follows? So my thought was more that instead of as follows, so say it shall comply with 527 CMR, but instead of as follows, say including without limitation, because it seems to be that these 4 items are of
These are the ones that are-
specific
yeah.
concern to them.
Right.
So
So.
that was,
Right, so let me.
that was my suggestion.
So I'll rephrase this. Fire department access into and out of the property shall comply with all state laws and regulatory requirements, including without limitation 527 CMR Section 1. Compliance with such,
I might be able to suggest something.
go ahead.
Including without limitation the following provisions of 527 1.0, and then you list
Right.
those 4. Would
I
that
would-
do it?
That's fine, yes.
Okay.
Good.
It might just make it a little less wordy.
Okay.
Yep.
We're up to demolition plan. D, demolition plan. A demolition plan shall be included with the revised project plans and to include the following. 1, removal protection of existing utilities and drainage for infrastructure. 2, tree clearing. 3, removal of asphalt saw cutting. And 4, removal of structures. E, grading plans. Before I go on, so again, these are all, I just make, these are conditions that are all prior to application for a building permit. Okay. Grading plans. 1, cut and fill analysis, including the destination of any soil that may need to be removed from the property in order to verify compliance with local earth removal regulations. 2, retaining walls greater than 6 feet in height shall be located no closer than 8 feet to a property line. Due to the proximity of proposed retaining walls to abutting properties, the applicant shall provide details on methods of construction that will be employed to ensure there is no disturbance of abutting properties. 3, retaining walls shall be located a minimum of 10 feet from any structure or dwelling unit within the project in order to support public safety, access, and provide sufficient natural light and air for residents of the project. F, limits of work. Clear indication of the limit of work to implement the proposed construction and detailed survey data, including spot elevations due to the proximity of the proposed work to abutting properties. G, utility plans. 1, utility plans including individual service locations and showing all pipe inverts, pump calculations, and profiles. The design shall provide adequate separation, including consideration of the depth of utilities for repair and maintenance of all utilities in accordance with utility provider requirements and standard engineering practice. Details of all utility components shall be shown on the plans, including but not limited to catch basins, utility manholes, utility trench construction, water system components, wastewater disposal system components, conduit duct banks, etc. Materials used shall be consistent with utility provider requirements. 2, flow test results and will serve letter from Aquarian Water Company to demonstrate that there is an adequate water supply for fire protection and water supply. Is that, Emily, water supply for the project itself?
Yeah,
And water
water
supply
supply.
for the project itself?
You could probably add, say, domestic water supply.
Okay, yep. For fire protection and domestic water supply. That's the change there. 3, fire hydrants in a number and location approved by the fire department and not greater than 800 feet from any dwelling unit in the project.
Okay, so before you, I just want to make one note. when going through the waivers, there was a number of places where you said, we'll propose, we may not
Right.
waive, but may do partial waiver by condition. I don't know if you wanted to get in that level of detail now. I'll just note, when you talked about the setbacks, which was on the bottom of page 3,
Yep.
that would have been cross-referenced. So typically, if the board was going to partially waive or waive to the extent of what,
Right.
in a final decision, the board, once you have the condition numbers set, there would be a cross-reference. So, for example, A1 and 2 on the bottom of page 3, I believe the cut and fill analysis, which is E1 on page 6. I don't know if you want us to try to note those or call those out as we go, or,
It'd be helpful just, to note that we are adjusting in these conditions a number of the items that we talked about in the waiver section, saying
Yep.
waive, but only to the extent that there are appropriate conditions that would support such a waiver.
okay, so for example, I'm sorry that I've backed up a little bit, but in E2 on page 6, which is retaining walls greater than 6 feet in height shall be located no closer than 8 feet to a property line. If they're greater than 6 feet, they're a structure, so that's a waiver, right? That's being
And this
granted.
is one we mentioned earlier, the applicant has not requested this waiver, but the plans depicted would require it. So earlier, we talked about waiving for dwelling units, no waiver, and then for decks, a partial waiver. But we, in the waiver list, to the extent that they've not requested the waiver, didn't grant any relief for
We
these
didn't grant, right, but we
structures.
are imposing appropriate
Right, to
conditions for
the,
that.
right, to the.
Yeah, but, yeah, we'll
right.
have to-
I would just say, to the extent that something has been discussed by the board and was of concern, my recommendation was to kind of belt and suspenders again, right? So, it's considered a structure, but since there's specific as to decks, I thought that you should be specific as to other setback structures. So that was my recommendation to Emily.
Right.
In the condition, but then how do we handle that in the waiver list? Because does the board have to actually grant a waiver that they've not requested?
Well, they have
To go
asked
along with this.
I think I read the setback waiver. They have a front yard, a side yard, it would just be like the retaining walls.
It's a side yard.
It's a side, well, is this 35 feet here off of?
This is 35, so they don't need front yard, they need side yard.
So they need side yard.
Yep.
So to the extent they've requested side yard setbacks of 10 feet.
But it's closer than 10 feet, so it's
Right.
approximately 8 feet. So they've not requested this relief. It would be something that I think we'd need to go back, and you would partially grant, potentially, a waiver of the side yard setback for retaining walls to be consistent with this condition. That
Yes.
makes sense?
Right, I think these are the fine details that we have to, have the board consider, and then have Emily and I incorporate them appropriately.
Right.
But I just wanted to flag them.
Yeah, no, that's important, and, I think that for purposes of this review and of informing the applicant of where we're at, I think their understanding is that to the extent that we are imposing a condition that in effect alters some other provision of the bylaw, that the condition supersedes the bylaw, and they can treat that as a partial waiver, but it's the condition that actually governs.
Right, and is there the condition, I'm trying to remember now, because I was looked at these last week, the condition that, except to the extent expressly waived?
Yep, we
So,
glossed over it earlier.
So it's
Yeah.
really, unless to the extent expressly waived, either in the waiver or in
a
the
condition.
conditions.
Right.
That's right.
Okay,
Then, so there would be no waiver unless expressly waived in the waiver provisions or specifically conditioned in the conditions. And I think council,
okay, so that's in the top of.
following, you understand
Yes.
what?
Well, I'm following, and also the issue of waivers to the extent that these fine-tuning issues,
Yep.
and that's the whole point about a moving target on a waiver list, okay, is that you will have a waiver for the retaining wall. So, we will certainly do that, but continue on your way.
Okay, so I'm just going to make a note
Yeah.
for A5, which is on the top page 2, where it says, except to the extent, unless expressly waived in attachment C, which is the waiver list, we'll put in a reference to specific conditions. Okay.
Okay. And I believe we're now up to H, stormwater? Is that correct?
Yep.
Okay, stormwater. 1, the applicant shall perform a minimum of 1 test pit soil elevation witnessed by an appropriate agent of the town or its designee at the site of each proposed infiltration system to verify soil textural analysis and depth to seasonal high groundwater prior to the submission of revised project plans. Test pits shall be excavated to a minimum depth of 4 feet below the proposed bottom of each infiltration system and shall be witnessed by an agent of the town or its designee. Test pit logs shall be submitted to the zoning administrator. The following actions shall be required based on test pit results. 1, if the test pits confirm assumed soil texture analysis and depth to seasonal high groundwater, then no further action is required. 2, if the test pits indicate more restrictive soil texture than the design of the infiltration systems shall be reevaluated. Results of the reevaluation shall be submitted to the zoning administrator for review. 3, if the seasonal high groundwater is found to be less than 4 feet from the bottom of any infiltration system, a mounding analysis shall be performed and results submitted to the zoning administrator for review. 4, if seasonal high groundwater is found to be less than 2 feet from the bottom of any infiltration system, the system shall be redesigned to provide a minimum of 2 feet of separation. 5, any modifications to an infiltration system design shall be submitted to the zoning administrator for review. 2, the applicant shall submit a final stormwater management plan and supporting calculations that document compliance with the DEP stormwater management performance standards. The plan shall include, but not be limited to, spot grades, limits of various soil components, infrastructure specifications, and a construction period and post-construction stormwater system operation and maintenance plan. 3, the applicant shall submit a stormwater pollution prevention plan consistent with National Pollution Discharge Elimination System construction stormwater general permit for review at least 1 month prior to submission of a building permit application. 4, flared end sections shall be reinforced concrete. Plastic flared end sections are not allowed. 5, verification of outlet configuration and modeling, i.e. topography around the entire wetland to clearly show the outlets to confirm that increase in volume of stormwater runoff to the wetland area to the east side of the development will not impact adjacent properties. I, lighting plans. 1, photometric plan with values not exceeding 0 candle foot overspill at any property line.
So that's a denied waiver under the request for waiver from submissions.
Right.
For the lighting plan.
2, details and specifications for proposed light post and building light, if any. 3, all site lighting shall be dark sky compliant. 4, color temperature of any outdoor light source shall not exceed 3,500 Kelvin. 5, building mounted lighting, if any, shall be located at entries mounted no higher than 8 feet above finished grade and downward directed. No floodlights shall be permitted. J, landscaping plans. 1, detailed landscape plan, including materials list specifying planting size and species, including a minimum of 1 roadway tree not less than 12 feet in height per unit on each side of the internal roadways. A minimum of 4 roadway trees shall additionally be required along the project's southerly Ward Street frontage. Roadway trees shall not be less than 12 feet in height and of a species selected by the Hingham Shade Tree Committee's list of deciduous tree recommendations revised as of the winter 2018. A mix of evergreen and deciduous trees, shrubs, and other plantings shall be shown on a portion of the former Viking Lane between the 3 visitor parking spaces. Did I skip something?
Oh, no, sorry, go ahead. I have a comment when you finish.
Between the 3 visitor parking spaces and the project's northerly Ward Street frontage.
Okay, now I have a question.
Yes.
Is there a Shade Tree Committee list of deciduous tree recommendations dated prior to or in existence as of the date of this application?
I believe so, prior to the date. I know there's one that predates winter 2018.
Right.
Whether it existed prior to 2016, when this application was completed, I can confirm.
Okay, I think we should just confirm and find out, and, I know there's a shade tree list of recommendations, it just came out, this application's been here for a while. I do know that we also have the tree warden who can make recommendations as to height and species. The regulations
Right, but
only require
These-
compliance.
They're
So
just
I wanna-
recommendations. So
Right,
I
so
think this
it-
board would be saying,
Right.
we want trees, this is where these trees would be appropriate.
Right, I'm with you, we don't want to retroactively apply new
Right.
regulations, but in my view, this is not a
Recommendation.
regulation, this is basically, if there's a regulation to have
Recommendation,
trees,
okay.
what are the appropriate trees?
Okay, I just wanted to
Right.
make sure we vet that question.
And I guess we can add in something that if the applicant finds that the revised winter 2018 edition is overly restrictive, they should so inform us so that we can so inform the zoning administrator so that we can
Okay,
consider appropriate changes.
right, because they could always
It's just that
consult
we
with
don't
the
want,
tree.
Right, we're
like,
not trying to
invasive
make-
species in the
Right.
town, or,
Right,
We're not
I'm just trying
Good
to
point.
look at it through the eyes of the applicant and say, what's the basis for this, and have that conversation so that it can be thought about before our next meeting.
Right. But in many ways, and this may be an oversimplification, if there was a list of, for example, forget trees, cars, of approved cars, and now, 3 years later, there's now, new cars out, we're not going to require them to do a 2016 car when 2018s are the ones that are now being used. So that's sort of
Okay.
a gross oversimplification. It's still the concept of the trees here.
Okay. Is that, maybe that's a list that Emily
Yeah.
can email to the applicant?
it was
Is
read
available?
into the record at a prior meeting. It's been
Okay, so as long as
provided.
they have it, so if they're going to provide potentially feedback to the board, I just want to make sure they have that list.
Yep.
Okay.
Okay, and now I think we're on page
Sorry.
9.2. A minimum of 10-foot buffer area planted with a mix of evergreen and deciduous trees and shrubs to present a reasonably opaque natural barrier to a height of 10 feet shall be planted along the rear of the units in the project and all side and rear property lines. No fence greater than 4 feet in height shall be located within the front yard along Ward Street. And then 3, dedicated play area for children residing in the project. Are we having any conditions associated with that play area? Or just that?
No, later, we just require that they provide the details associated with it, but,
Okay.
yeah, no other specifics.
K, detailed plans. 1, retaining wall details prepared by a structural engineer for each wall in excess of 4 feet in height. The details shall specify structural concrete with a stone facing. 2, detail or specification sheet for the proposed 6-foot high vinyl privacy fence shown on the preliminary landscape plan. And 3, details for the equipment and surfacing of the dedicated play area required by prior conditions C1J5. L, architectural plans, elevation plan.
Yeah.
You okay?
Yeah, it's just, we'll
correct
true
it.
this up later.
Okay.
It's already changed.
Architectural plans, 1, elevation plans consistent with those depicted on the typical building elevations referenced in the project plans. 2, building topology shall be consistent with the architectural plans included in project plans with a mix of single-family, two-family, three-family, and four-family dwelling units. Buildings shall not exceed more than 4 attached townhouse-style dwelling units. 2, we're moving on to a new section, vernal pool studies. I'll pause first. Any other comments or questions?
No, but vernal pools, obviously, that was covered in the waiver list.
Yes. So now we're going to be addressing specifically vernal pool studies. A confined depression within the western lobe of the bordering vegetated wetland meets the physical and biological criteria necessary to quality? Qualify, okay. And is positively confirmed as a vernal pool in order to protect the wildlife habitat interest associated with the vernal pool resource area, the applicant shall complete the following. A, conduct additional field investigations during the months of April and May to determine the presence or absence of obligate, is that the right way?
Obligate, yes.
Obligate vernal pool breeding amphibians within the pool and provide documentation to the zoning administrator regarding the findings. If obligate vernal pool breeding amphibians are present, the associated upland dispersal habitat within the buffer zone to the vernal pool shall also be identified. So what is B, I'm assuming at the top of the page 10, that should
Yes.
be B.
Yep.
Provide a narrative describing how the vernal pool habitat will be protected against adverse impacts associated with the proposed project, including the removal of buffer zone vegetation, modifications to hydrologic regime of the vernal pool, and best management practices to be implemented during construction. 3, Autumn Circle Access Road and related improvements. The project plans propose to connect the internal roadway from the project to Autumn Circle by way of an access road through a purported access easement or right-of-way over a public drainage easement and portions of abutting property in order to both accommodate safe vehicular and pedestrian travel for residents, visitors, and abutters, and public safety responders, and mitigate project-related impacts on Autumn Circle. The applicant shall revise the project plans prior to application for a building permit to include the following. A, identify the ownership of the proposed access road between 18 and 23 Autumn Circle and the rights of others for its use. B, design performance standards for the proposed conversion of the existing Autumn Circle cul-de-sac to a roundabout, to include I, the circulating area within the roundabout shall provide a 30-foot wide paved area with the inner circle designed to be traversable by an emergency vehicle and constructed of either sloped granite curbing or a flat cobblestone center that will support the weight of the Hingham Fire Department design vehicle. 2, the roundabout shall be designed so as not to inhibit access to the residential properties abutting the roundabout or require that motorists exiting driveways within the roundabout back up into the circulating area. And 3, the roundabout shall allow for on-street parking without impeding circulation within the paved area or inhibiting emergency vehicle access. C, submit a plan for additional traffic calming features, pedestrian improvements, and other appropriate measures to address travel speeds and the increased traffic, including that generated by the project and potential cut-through traffic between Ward Street and High Street that will be using Autumn Circle. The plan shall include a dedicated bus stop for school children at the intersection of Autumn Circle and High Street. D, submit a plan for a sidewalk with a minimum width of 5 feet to be constructed on the north side of Autumn Circle between the secondary project drive and High Street to conform to Town of Hingham, DPW, Highway Department standards for public sidewalks within a public right-of-way. 3, High Street, French Street, Ward Street improvements. In an effort to mitigate project-related impacts on the intersection of High Street, French Street, Ward Street, the applicant has agreed to conduct a road safety audit in order to identify corrective measures that can be undertaken at the intersection to improve safety. A, prior to the application for a building permit, the applicant shall facilitate and fund the completion of that study, of that audit, to identify both short and long-term measures to improve safety at the intersection. The audit shall be conducted by an independent consultant retained by the applicant with experience in preparing road safety audits, and the road safety audit shall follow the Mass DOT road safety audit guidelines. B, copies of the draft and final road safety audit shall be provided to the zoning administrator, Department of Public Works, town engineer, and police department. C, pending completion of the road safety audit, the applicant shall design the short-term improvements identified as part of the road safety audit. Said plans to be filed prior to application for a building permit. help me to understand this one, Emily. Pending completion of the road safety audit, they're going to design the short-term improvements identified as part of the road. How do they, if the audit hasn't been
Yeah.
completed, how's that happen?
They have to complete the, so following complete, maybe instead of pending, say following
say
completion
following
of the road safety audit.
Or to put it differently, if there are short-term improvements identified prior to the completion of the audit. Is that where you're going with that?
No, the road safety audit would have a list of short-term
Okay.
improvements, long-term improvements, so they would have to complete it.
Okay, so...
And the road safety audits typically don't take a long time to complete.
Okay,
I
so-
mean, maybe a month tops.
So C will be amended to read, following completion of the road safety audit. Okay. Instead of pending. We're up to 4, wastewater disposal.
So this is obviously from,
Speak up, so.
I'm sorry, so this is also from, relates back to the waivers that were discussed earlier.
Yes, because we had specific discussions about wastewater disposal in our waiver review. So we're out now at number 4, wastewater disposal. The wastewater disposal system shall be designed in full compliance with Title V and all local Board of Health supplementary rules and regulations for the disposal of sanitary sewage not otherwise expressly waived in our waivers,
That should be,
and the conditions set forth below. A, in an effort to minimize project-related impacts related to nitrogen loading on private drinking well waters in the area, the applicant shall design the on-site wastewater disposal system as follows. 1, as the maximum daily sewage flow for the project exceeds 7,500 gallons per day, the applicant shall file a permit for a plant with the zoning administrator. In connection with the filing, the applicant shall provide 6 sets of plans prepared by a registered professional engineer. Said permit shall be subject to peer review to confirm compliance with all local Board of Health supplementary septic regulations not expressly waived in our decision and the conditions set forth below. 2, in accordance with a partial waiver from Section 6.8 of the local Board of Health supplementary septic regulations, no sewage disposal system serving the project shall be designed to discharge more than 110 gallons of design flow per day per 10,000 square feet in lot area. So this relates then directly to that waiver that we previously discussed. 3, in accordance with a partial waiver from Section 6.8 of the local Board of Health supplementary septic regulations, the applicant shall provide the following analyses identified in Title V of the State Environmental Code guidelines relative to nutrient loading and nitrogen sensitivity. This information reflects the components of a basic septic site-specific mass balance analysis. 1, hydrogeologic assessment. 2, mounding analysis. 3, nitrogen analysis. 4, groundwater monitoring program. B, as an alternate to compliance with the subsection A that I just read, the applicant shall provide an advanced treatment denitrifying, I don't think I pronounced that right.
Yep.
I didn't. Nitrifying wastewater disposal system, which shall provide a level of treatment which would limit concentration of nitrate nitrogen in groundwater to 10 milligrams per liter at the project property boundaries. Calculations shall be submitted to document that the design of the system will comply with this condition. So just so I'm clear, this B is an alternative to A.
Correct.
Okay, and then we move on to C.
okay. I guess there's I'm sorry. The question on, would these reports still be applicable to B? Or needed, or?
Under Title V, some of them would still be applicable. Under Title V.
So when you say as an alternate, does that mean that A3 wouldn't apply, or would A3 still, so should just be revised to, so that even if they do the alternative B, these reports should still be provided?
Well, so Pat, you're saying some of them still would be provided under Title V, and the
Correct.
others would potentially not be necessary?
At least the mounting analysis, the nitrogen analysis.
Okay, so I think we should have B saying that even if the B alternative is selected, that is not a waiver of the requirements that Title V would otherwise require.
Right.
Got that? Okay.
If we need to so state, because we can't do that anyway,
Right,
but.
right. Now we're up to letter C. All septic components under roadways shall be designed for loading of the Hingham Fire Department's largest apparatus, tower ladder. Leaching system piping under roadways shall consist of Schedule 80 PVC. D, new test pits shall be conducted and systematically located to confirm the subsurface characteristics of the soils in the area of the proposed soil absorption system. And E, separation from high groundwater shall be circulated after adding the effect of groundwater,
Shall be calculated.
shall be calculated after adding the effect of groundwater mounting to the high groundwater elevation as determined pursuant to 310 CMR Section 15103, sub 3.
I just have a question as for the board on, if you go back to A1,
I'm sorry, go ahead.
on A1, it says shall be subject to peer review, and the other places where the board discusses peer review, it's specific or express that the applicant shall provide peer review funds to cover that cost of the peer review. So just for consistency.
We had a discussion, sorry to do this on the
No,
fly,
go ahead.
where if the board imposes these conditions or doesn't waive certain local requirements, the plan submitted to the Board of Health under their state review would also have to comply with these, and that the
Yep.
Board of Health has the ability to conduct peer review under
Under the
state regulations.
States, okay.
But my one concern with that is that typically peer review is done pursuant to the local regulation, as long as we didn't waive.
Right.
The
You're
problem,
saying peer review under Title V
Yeah.
is done pursuant to local regulation.
any local board's ability to do peer review generally is done pursuant to a local regulation. You have to adopt local regulations in order to do it, even though you have the authority to do it under the state regulations. Is that,
Right, so nothing we have done has waived any board's authority to impose fees or conduct activities with respect to state mandated obligations.
Right, and I'm not suggesting that. I mean, what my only suggestion here is, or question, is it says it shall be subject to peer review, so therefore you're not waiving it, and you're making express it's required. In all the other places that you talk about peer review, unless, Emily, you feel like it's covered at your introductory one, where you may require it, I just want to make sure that it's clear that the peer review is done at the expense of the applicant. That's my only question, whether we need to be specific about that.
Yes, the answer is yes.
general? Okay.
Okay. So, sorry, go ahead.
Pat's indicating that what we've suggested earlier in the process, earlier in this document of $5,000 should cover both your regular peer review and this peer review.
Okay.
Okay, we'll just, you know what, we'll go back and double check it and just be clear. Okay.
Okay, we're about to move on to conditions in effect during construction.
Right. I should note that should be D. D as in David. C
Because we-
Construction.
Where does it say that?
Yes,
A was
thank
general,
you.
right?
Yes, thank
C.
you.
See on page 3.
Conditions in effect during construction.
And two things, Mario has graciously agreed to
Take over.
take over, and I've actually finished this huge water bottle.
I haven't opened mine, so
I'm
I'll
going to
pass
go, I
it
can just
down.
go fill this, because you may need it
Okay.
later. So if you want to start, I've read it, and I'll be right back. I'm just going to go.
Mr. Chair, can we just take a 2-minute recess? And I'm going to,
That works. Okay.
Thank you.
Okay.
2-minute recess.
Take a recess.
Okay, we are going to resume.
tomorrow.
We are up to what, we're now on page 12 of our conditions, at the bottom of the page, which was labeled C, it is now corrected to D. Conditions in effect during construction. Please.
All right, so D, conditions in effect during construction. 1, a copy of this comprehensive permit shall be kept on the work site at all times during construction. The applicant is responsible for providing a copy to all contractors and subcontractors for informing them of its requirements and for ensuring compliance with the conditions. 2, the applicant shall comply with the state building code and any local regulations or fees of the Hingham Building Commissioner. The applicant shall pay all required fees for all such building and other permits including any fees charged for inspections and permits. 3, the board's agents may enter onto and view the site during regular business hours to ensure compliance with the terms of this decision, subject to applicable safety requirements. 4, the applicant may display one unlighted temporary construction or marketing sign not exceeding 12 square feet at the site entrance stating appropriate marketing information on the site, provided it otherwise complies with Section 4B of the zoning bylaw. The temporary construction and marketing sign shall be displayed for no longer than 3 years from the date of issuance of this permit, which term shall be renewable at the board's discretion. 5, during construction, all deliveries of construction materials and equipment shall be made only on Monday through Friday, no earlier than 7 a.m. and not later than 5 p.m., as provided in condition B, period 3. No construction vehicles or deliveries of construction materials shall be permitted to access or exit the project site by way of Autumn Circle. Construction operations shall be limited to the hours of 7 a.m. to 6 p.m. Monday through Friday and 8 a.m. to 4 p.m. on Saturday. After-hour activities shall be limited to interior work within a fully enclosed building and site cleanup. Except for emergency conditions, no exterior construction work shall be allowed on Sundays. The building department shall be notified promptly of any such emergency conditions. Hours of operations may be enforced by the police department. Throughout the construction, the applicant shall comply with all local, state, and federal laws in effect as of the date of the application regarding noise, vibration, dust, and blocking of roadways.
I'm sorry, Maureen, I just have a question. Emily, is there an emergency phone number for the building department on Sundays, or should they be contacting the police department?
So I know they're on call. I don't know how anybody gets in touch with them, so maybe it is the police department.
I would just suggest, because that's talking about emergencies on Sundays, and I don't know if there's an emergency number for the building department, or if you have to go through the police department to get them.
Well, the alternative would be that we have a pre-construction meeting at the beginning of the process where we could provide to the site contractor the building
Emergency numbers,
commissioner's cell
emergency
phone
numbers.
number. Yeah.
Okay, whatever you think, Emily.
Either way, it's,
Okay.
Okay?
I just think a voicemail message to the building
Yeah,
department on
it's not-
Sunday is
Right.
not
Yeah.
too helpful. Okay.
yeah.
Before going on, I'm reading that there's basically no construction activity allowed on Autumn Circle or traffic going through Autumn Circle, but there's going to be work to convert the roundabout?
Cul-de-sac and the
Yeah,
sidewalk,
so-
possibly, yes.
Right, so I'm assuming that is a
Right.
exclusion?
Yeah.
So we need to make that explicit? Right.
Good.
Okay.
All right, you got that one, Emily? All right, 6, during the period of construction and marketing, notwithstanding any preconditions for the issuance of a certificate of occupancy otherwise set forth herein, the applicant shall be entitled to designate, construct, and operate up to one of the units as decorated model units, but not to be used as inhabitable units.
As habitable. Yeah. Double negative
won't
there.
mark
Double
Getcha.
negative, yeah.
We're not going to be marketing any
Sorry.
inhabitable units.
That's why we're reading them, right?
Yes.
Number 7, during construction, the applicant shall be able to locate up to 2 construction trailers unless additional trailers are otherwise permitted by the building commissioner on the property. All construction trailers shall be located within the fenced construction area of the project. Placement, operation, and maintenance of the construction trailers shall not adversely impact parking, safety, or the surrounding neighborhood. Other conditions of this decision required to be satisfied prior to issuance of the building permit or certificate of occupancy shall not apply to the building permits or certificates of occupancy required for the construction trailers. Number 8, portable bathroom facilities, trash containers, and portable generators shall be located within the fenced construction area for the project, at least 50 feet from the boundary of the property. Number 9, during the period of construction, no construction worker vehicles and no construction equipment, parentheses, unless in connection with off-site mitigation while such work is underway, close parentheses, shall be parked on any public or private way. Number 10, during the period of construction, no construction vehicles or construction worker vehicles shall be permitted to idle their vehicles for more than 5 minutes.
1 second.
Yeah.
We are now more than three-quarters of the way through, just to give people the...
Can I, in number 9, when it says, no vehicles or equipment shall be parked on any public or private way, I mean, there's going to be private way within, so we're talking about outside of the project, right? Outside of the project.
Yes. I'm sorry to interrupt.
That's okay. So 10 again, during the period of construction, no construction vehicles or construction worker vehicles shall be permitted to idle their vehicles for more than 5 minutes in accordance with Mass General Law, Chapter 90, Section 16A, and 310 CMR 7.11. 11. Number 11. During the period of construction, the applicant shall implement the construction period pollution prevention plan and erosion control plan until the site is fully stabilized and the temporary erosion and sediment controls are removed.
I have a comment on this one. We're already requiring, as they're going to have to apply for the NPDES construction general for coverage under the general permit, and they're going to have to prepare the stormwater pollution prevention plan. That's essentially the same thing, and I think we should substitute SWIP here for, just to be clear.
Yep.
I agree.
Right.
Okay, number 12.
Yeah.
During the period of construction, pavement areas, parentheses, including Ward Street, within the 100-foot buffer zone shall be swept daily at a minimum and more frequently as necessary to prevent tracking of soil into wetland resource areas and or stormwater management facilities. 13, during the period of construction, there shall be no stockpiling of soil or other materials within 100 feet of the wetland resource area. Stockpiles shall be protected with erosion control barriers or other means as necessary. Any soil stockpiles that will remain unworked for greater than 14 days shall be seeded with an annual ryegrass or equivalent seed mixture. 14, no construction materials, debris, or stumps shall be buried within 100 feet of a wetland resource area.
Now we're up to what is labeled D, but it's really E.
Yes, but I apologize. During the waiver discussion, we had discussed certain measures to protect the sewage disposal system.
Yes.
From compaction, if that's installed before building construction or not installed. So we might add item 15 to reflect the discussion we had with that waiver request.
What wordage, because we've got to make sure the applicant has it.
What the Board of Health had recommended, so what they had said in connection with that waiver is that they expect the applicant to protect the soil from compaction before, during, and at the conclusion of construction of all structures. Do we have any sort of performance standards that we could attach to that, or other language?
For the soil absorption
Forward
system,
that
there
to me.
is roadway on top of the soil absorption system. So I would say any of the area outside of the roadway needs to be protected during those periods. But we've already asked for, we're already requiring Schedule 80 piping,
Right.
so the loading should be okay, but I understand the concern with compacting the soils underneath that system. I would say once it's installed, it's okay, but prior to it
Yeah.
being installed, it should not be, construction equipment should not be allowed to traverse over that area.
So should we say it should be fenced off, or just tell them that they can't do it? I don't know.
I think the only way to ensure that it doesn't get traversed is to fence it off.
Trampled,
Is
yeah.
to fence it off.
Fence
Or
it off.
mark it somehow so that
Yeah.
people know. Because this is a common
I know
problem.
my guys with loaders and stuff, they just run over.
Right,
you
it's a
know.
common problem.
Yeah.
Right.
We'll draft. We have notes on it, we'll consolidate the notes and comments and,
So when we can get the language, okay.
yeah,
Okay.
I mean, at the end, we can talk about what we're going to do
Yeah. Okay.
after all of this input from the board.
Right, okay.
Right.
So we are up to what was marked as D, and now it's E, which is occupancy-related conditions. Want to keep going, or do you want to switch? Okay, go ahead.
Occupancy-related conditions. 1, as-built plans. Prior to the issuance of certificates of occupancy for more than 85% of the dwelling units within the project, the applicant shall submit as-built site and building plans stamped by the appropriate qualified professional with a certification that all site work improvements have been completed in accordance with the approved plans. 2, traffic improvements. Prior to the issuance of any certificate of occupancy for the project, in order to provide safe and efficient vehicular and pedestrian access to and from the project, and to promote public health, safety, and welfare of the residents of the project and the public, and to address the project's projected impacts on transportation and pedestrian infrastructure, the applicant shall complete the traffic improvements in accordance with the approved plans and as described below. A, internal roadway improvements. In order to accommodate safe vehicular and pedestrian travel for residents, visitors, and public safety responders, the applicant shall design and construct the following improvements in accordance with the approved plans. 1, all internal roads shall maintain a minimum width of 24 feet and a sidewalk at minimum of one side of each roadway. 2, traffic calming devices to include raised crosswalks and a speed table on Road C shall be completed in an effort to minimize the potential for cut-through traffic and reduce vehicle travel speeds within the project. 3, given the extent of the regrading activities that will be required to provide the necessary sight lines from both Road C and Road D, the applicant shall submit an affidavit from a professional engineer certifying that the required minimum sight lines are met at the project site roadway intersections after the completion of the improvements.
Mario, I just stop for a second. I guess there's some redundancy, not completely. So there's the issues of what we talked about earlier, which is revisions that were required to the plan. So for example, the 24-foot width and the sidewalk on each side. So I don't know if you need it again here. The same, and again, I guess I'd ask maybe Pat, if something like the traffic calming measures, including raised sidewalk, speed table, should that be in the section that talks about the plans need to be revised to reflect these?
Well, so
Or-
these items are actually already shown on the plan. I think the intent of the recommendations, as they were at some point from our traffic peer
Right.
review engineer, is that these things actually be installed prior to issuance of any occupancy permit.
Okay.
So I think maybe that's what's not coming across as very clear.
Okay.
So item
Yeah,
one is saying,
confused.
you know, lots of things need to be done before more than 85% of the COs are issued. I think these other more specific sections were intended to be prior to issuance of any occupancy
Right.
permit, but it's
So-
not.
Well, I
it's not
think that is clear, because beginning of
Okay.
2 says prior to
yeah,
the
it is
issuance
clear,
of any
sorry.
certificate of occupancy for the project,
Right.
then we have to do,
Oh, they have to complete them?
yes.
Okay, as
Right.
opposed
So-
to, all right.
So I don't think this is redundant. I think this is necessary.
Yeah.
Okay, and is 2 something that's already discussed in the?
It's shown
plans?
on the plans.
Need to be shown on the plans?
They already are shown on the
They're
plans.
already shown on the plans?
Yeah.
All right, I'm sorry, maybe it's the hour, I just was not following it.
No, it's confusing.
We're
sorry.
now at which one?
B.
At B.
High Street.
High Street.
High French
so
and Ward
B.
Streets. Yeah.
High Street, French Street, Ward Street improvements. In an effort to mitigate project-related impacts to the intersection of High Street, French Street, Ward Street, and prior to issuance of any certificate of occupancy for the project, the applicant shall, 1, construct short-term improvements identified in the RSA, subject to receipt of all necessary rights, permits, and approvals. Or, 2, in the alternative, the applicant shall provide funds to the town in the amount of up to $30,000 to be used towards the design and construction of the short-term improvements identified in the RSA.
I guess the question is, it says up to, but how do we, if it's not 30,000, who's determining what that number is?
No.
Presumably the peer review engineer, because we do have some funds set aside earlier in the decision for
Okay.
traffic peer review. So if the short-term improvements cost less than $30,000, we won't require that they give us.
So why don't we
3,000?
revise this to say, in the alternative, the applicant shall provide funds to the town in the amount of $30,000, or such lesser amount if a lesser amount is in fact required. So, you know, it is required, to be used toward the design and construction of the short-term improvements identified in the RSA. So they're protected on the upside, and then they get the downside if in fact a lesser amount is required.
Okay.
Okay.
Then you're up to C.
C, autumn circle improvements prior to issuance, prior to issuance of any certificate of occupancy for the project. The applicant shall complete all improvements to autumn circle as identified in condition C2.
We're now up to stormwater improvements. Joe, do you want to take us home?
Sure. I'm just doing a quick search here to see what this is.
We're now,
Stormwater improvements, item 3. A, the applicant shall submit an operation and maintenance or O&M compliance statement prior to application for any certificate of occupancy. The O&M compliance statement shall identify the party responsible for implementation of the operation and maintenance plan and confirm the following. 1, the site has been inspected for erosion and appropriate steps have been taken to permanently stabilize any eroded areas. 2, all aspects of the stormwater BMPs have been inspected for damage, wear, and malfunction, and appropriate steps have been taken to repair or replace the system or portions of the system so that stormwater at the site may be managed in accordance with the stormwater management standards. 3, that the operation and maintenance plan is being implemented. And 4, future responsible parties have been notified by recorded instrument of their continuing legal responsibility to operate and maintain the structures. And that's finishes stormwater. Now, item should be F, post-construction and ongoing conditions. Item 1, the applicant shall undertake the following measures to maintain sight lines. A, ensure that signs, landscaping, and other features located within the site triangle areas of the project site driveway intersection with Ward Street do not impede lines of sight. Such features shall be maintained so as to not exceed 2 feet in height as measured from the surface elevation of the project site driveway. A recorded easement shall be secured by the applicant to limit features greater than 2 feet in height within any portion of the site triangle area that crosses private property. B, promptly remove snow windrows located within the site triangle areas of the project driveway intersection with Ward Street and at intersections within the project that exceed 2.5 feet in height or that would otherwise inhibit sightlines. 2, parking outside of designated areas within the project shall be prohibited in order to ensure that sufficient maneuvering areas are afforded for public safety vehicles. 3, the stormwater drainage system shall be operated and maintained by the applicant in accordance with the operation and maintenance plan included in the drainage report revised through March 9th, 2018, as prepared by McKenzie Engineering. And 4, the applicant shall remove snow from the site as soon as practicable following large snow events when the site cannot itself accommodate snow storage without a loss of driving aisles. No snow shall be removed from the project onto any adjoining properties, including Autumn Circle, the Autumn Circle Access Road, or Ward Street.
If I can just interrupt for a second. Item 3, I think it should,
25,
I think it should, in accordance with the operation and maintenance plan submitted under, and we'll reference the condition it was submitted under, because there wasn't one included in that
Okay.
report.
It was not. Okay.
Correct.
Oh, yeah, you're right. Okay.
Okay, submitted under item,
Under condition blank. Okay.
Yeah.
right. Okay. And folks, believe it or not, the last set of conditions.
Which is G.
G, affordability conditions. 1, the project shall provide no fewer than 25% of the units to households at or below 80% of the area median income, subject to all applicable requirements of the subsidizing agency for the project, the so-called affordable units. Item 2, upon submission by the town to the applicant of the supporting documentation and justification pursuant to Section 3D of the General Laws, Chapter 40B Comprehensive Permit Guidelines, the applicant shall prepare an affirmative fair marketing plan, which includes local preference for review by and subject to the approval of the subsidizing agency. 3, the affordable units in the project shall remain affordable in perpetuity. And finally, 4, the applicant shall make provisions for a monitoring agent to assure the functions specified in the regulatory agreement following expiration of the subsidizing agency's monitoring role. The form of these provisions shall be submitted prior to application for a building permit and subject to review by town council.
Okay, so before we congratulate ourselves, any other conditions, Emily, that you think we...
Yes, I
Okay.
apologize.
Just make sure you speak up. So.
Yep. So, let me find it. I think I have just one. So during the waiver discussion, we had also talked about imposing a condition that alarms be added to the septic system in the event of failure. So on page 12, so we could potentially add item F to include that condition.
So page 12.
Yep.
These are not conditions in effect. This is above...
These are plan change requirements,
Okay.
and that's in the wastewater section.
Okay. So what language would you propose?
That alarm shall be added to the sewage disposal system?
Title 5 requires alarms for any pump system anyway, so I'm not sure what other alarms the local Board of Health, but they may not be required, because
Okay,
Title 5 requires that to begin with, so they're required anyway.
okay.
All right, well, why don't we talk to Pat and talk to the Board of Health, but we will
Have a placeholder.
have a
in-
placeholder for it, because at this point, we're not dotting every I and crossing every T. What we're trying to do is give
Right.
the applicant, the public, everyone, the sense of the conditions being, and the concept of applying alarms is something that was discussed. So we'll talk and get the appropriate language, and if it becomes not necessary, because it's already required, then the board can remove it when there's further discussion at your next meeting.
Well, it seems to me, though, that we should have a condition because we're going to be asking the applicant to consider these conditions. So
Yeah.
if it turns out that that it's not necessary because it's redundant
Yeah.
with what Title V provides, so be it. But I think I'd like to add that condition here. And it seems to me we're talking about a condition that this is alarms for the
Wastewater system.
for the wastewater treatment system.
Right.
Shall be implemented in a manner, is it some standard we can cite to, or?
Is required by Title V of the State Environmental Code.
But what if,
Oh, no, the Board of Health isn't here. I mean, I think they're the ones who mentioned it. I think it would be helpful if we
So,
could check
Or do we
in
want
with
to say
them.
the town supplemental regulations?
So we should say shall be, that those alarms shall be installed consistent with local Board of Health regulations.
but so they were recommending the alarms because you were waiving a requirement that the
Distance.
Oh, so they
leaching
don't have an
field.
alarm requirement
Separation.
otherwise?
I don't believe so. It's because they're going to have 466 feet instead of the maximum of 200 feet between a dwelling unit and a,
But we discussed waiving that requirement because there would be
Alarms.
numerous units within the 200 feet.
and/or, yes. So there's multiple ways that people would have notice, I think, that,
Right.
that there was a problem with the system or a failure in the system.
So we can really put the onus,
The pump station will already have a
Right.
alarm.
Any
you know,
pump
the
station.
septic
Right, any
system.
pump station's got to have an alarm.
Is there a pump station?
Yeah, there is a
Yep.
pump system here, so there will be an alarm as part of that pump
Yes,
system,
I
as
think
required
the
by
Do you know
code.
where is the
agent
pump
will
system
mention
in
the
relation to
soil
the
absorption
homes?
System.
So the pump system is, it's going to be right here next to Unit 1.
So how far would they, Unit 1 is at the, so the,
It's within 10 feet of Unit 1.
right, but how far do you think you can hear that alarm? Because what if someone's on vacation at Unit 1?
So
And there'll be a beacon. too.
Title V requires, if it's a single-family home, they require that the alarm be mounted inside the dwelling unit so that you can hear it.
not here.
On a community system like this, it's probably going to be mounted on a pedestal, because there's going to be some type of a doghouse or something to house the controls out there. So it'll probably be required to be mounted on the exterior of that shed or whatever it is, with a beacon and an audible alarm, because both are required.
Pat, the health agent mentioned the soil absorption system failing.
Street.
What-
Right.
We're not talking the pump station.
It's going to, if that fails and there's breakout, you're going to see it coming out. I
Right.
mean, and that's right, it's, part of it's under the road,
it's right
you're going
there,
to see it
so.
coming out. I mean, it's right, it's central to the development, so it's not, like she had mentioned, it
Right.
being out in the middle of the woods,
Right.
somebody's never going to know about it.
Right.
This you're going to know about pretty quickly.
Right. If it's out
I
back
bet
in
it
the
probably
back.
doesn't
Like,
smell
like
too good
segue
either.
something into like title, going from title five.
Right, so so can we say that the applicant shall present plans showing alarms that are in compliance with Title V and satisfactory to the zoning administrator?
Sure. Subject to peer review.
Well, right, I mean, obviously, we don't, the goal is not to impose something that's onerous.
Yep.
Right.
To let the applicant know that alarms are required, and if in fact, what I'm hearing, it's not clear to me that Title V requires the alarms that we're talking about.
Yeah, I'm not sure what
Yeah,
other
yeah.
alarm, because the Title V alarm is if the pump fails
Right.
and there's a high water situation.
Right, and that's not necessarily what was being addressed by the Board of
But I
Health.
don't know how you alarm.
But
what
this
they-
is, but, right, so, well, okay, so are we otherwise done?
Yep.
Yeah.
Okay, so the question is, you want me to try to run these, Emily's not going to be available till later in the day tomorrow. I could try to run through, Emily, if you send me the most recent Word version, all these changes, so that then when Emily's available later in the day, she can then circulate it to reflect what was discussed here.
Right.
As opposed to, just relying on everybody's notes.
I think that, right, but we need to,
Right, but then I can check with the Board of Health in the morning, see if they had something, or Susan Sarney in particular, see if they had something different, or, you know what I mean? Just confer and make sure everybody's on the same page
right.
in the morning, and then reflect that. And obviously, everyone knows this isn't final, but at least the applicant will have a better sense of what was being suggested, because I think it was the Board of Health representatives that were asking for that.
Right.
As a condition, if you waived the other, right? So does that work for you, or?
Yeah, I mean, I think if you're asking if the board will defer to your discussions to follow up on the public discussions we had with the Board of Health, so that we can reflect and hear the language that's consistent with what the Board of Health requested for alarms.
Well, then, so maybe just to be clear, and again, I apologize, I think it's the late hour, so I'm trying to process. I thought I heard you saying that you wanted a condition
I do.
that reflects what was being requested by
Yes.
the Board of Health. Okay, so then, based on, since that's what you're talking about
Yeah.
being in favor of,
Yep.
then, obviously, nothing I draft is binding on the board, but I will try to, appropriately reflect that conversation in a condition.
Yes.
And of course, when the board next meets, you have free to do whatever you want to that condition.
But that's not where we're at. We're adding tonight that we're going to
Yeah.
agree on the proposed conditions.
Right.
Not to be proposed at a subsequent meeting. So I want to make that clear.
Yes, okay, sorry. Yeah,
So that what we're proposing is that their condition be added for alarms.
right,
That would be consistent with what the Board of Health required, and that specificity you'll add in.
Yes.
But we've got the condition, right, so, because we're not going to
Yes.
make the applicant guess, we're going to have it.
yes,
Okay, great, perfect,
okay.
good. Any other conditions that we have not yet covered that we need to cover?
Not that I'm aware of.
Okay,
Can't think of anyone.
can you think of any?
Thank you.
Good.
I'll be brief.
Thank you.
The issue of the internal roadway, not having had the benefit of the document coming into here, I just want to make sure, is your understanding of internal roadway separate from the way that is in between the project site and Autumn Circle?
Yeah. The way between, that's proposed into Autumn Circle is referenced in the draft decision as the Autumn Circle access road.
Okay,
So the internal roadways are fully within the project site.
okay.
Right, they
So-
end at the property boundaries or at the street right away, along Ward Street.
Say that again?
They end at the property boundary or at the street right away on Ward Street.
Okay. I have a few proposed conditions right now, and I can just run, or just the concept of them through the board. We can get into more specificity at another time, but I just wanted to run a few of them.
Before you do, have
through the
you
board.
submitted them yet to, are these new conditions, or is this something that you're sort of refining what was previously submitted?
Well, I think that most of them would be refinements to what was either previously submitted or read this evening. Certainly kind of captured within them, but I have not submitted these words
Okay.
to the board. Essentially, I want to make sure that the way that's to be constructed, and just about every one of these is the concentration on the way, the private way that we talk about.
Right.
So is this where, this is the Autumn Circle access road?
The Autumn Circle access
Okay.
road. if
Which
that's
we
what
are
we're gonna
not
call it.
considering an internal way.
Okay,
Right.
yes.
Okay.
I just want to make sure that that is also required to be 24 feet in width, that is also required to have at least one sidewalk on one side with granite vertical curbing. That's ADA compliant. I would like the board to consider that there would be no snow storage on that particular access
Let me
road.
stop you. I think that one is specifically
we did.
covered
Yep.
Okay.
already.
All right. Utilities, I just want to make sure that any proposed utilities on that are underground. I'm not sure I heard that.
I don't think you did either.
I don't know that there
Are
are
any
any
utilities
proposed.
shown, proposed in that, Pat?
The only proposed utilities shown there is drainage
is
that's piped back onto the property.
Perfect. I did notice that as I was sitting here, and it was a little at odds with what I had heard
Right.
the engineer indicate there wouldn't even be a need for drainage over there, so I was a little confused by it.
But I think even though there are no utilities above ground that are shown, I think your point is well taken. I would be in favor of making that as a condition.
Okay, thank you. Also, I want to make sure that there's some language, and there might have been, that was read, that indicates that the improvements in the way shall not interfere with the driveways of 18 and 23 Autumn Circle. In other words,
So I'm with you, and I believe that we specifically addressed
It
that.
says, "The roundabout shall be designed so as not to inhibit access to the residential properties abutting the roundabout or require that motorists exiting driveways within the roundabout back up into the circulating area."
but that's the roundabout, and what I'm talking about is the access road itself.
Oh, I see.
Literally.
So
Okay.
Yeah, I mean.
He's saying, okay.
So I think that's a good point.
Thank you. Additionally, I want to make sure that, I think that you had it in there, that the applicant shall implement, construct, and maintain all of the recommendations of Vanass and Associates with respect to that access road. I think that was in there.
I don't think that is.
But it's assumed, yeah.
No, that's not there.
Well, it's shown on their plans as they're, right?
Right, but
Not these standards that we're hearing tonight, but presumably all the improvements that they're showing on their plans, they would build. So we could impose a condition.
Well, Jeff Dirk's suggested conditions are included in the set of conditions.
If they're included,
Yeah, they are.
that's the most important part.
Yes, yes. Okay.
That's what I care
They
about.
are.
Okay.
So I have two more, only two more, all right? One,
Build it?
Gesundheit.
one is that the,
Do we have to impose that?
I think that there should be a condition that indicates that the project in its final form must have 2 points of access to a public road for safety purposes. So this isn't necessarily the way, and you might have that. I didn't know.
Yep.
Emily seems to be indicating yes. And the final, the
Just one
final,
second, let me just check.
Yeah, it was added in there by someone.
Yeah, it's on the top of page 5, it was a condition recommended by abutter Ellie Hickey on 425.
Right.
2 means of access to the project with sufficient width and grade to accommodate.
that was one of the
pedestrian-
first that you read.
Yep.
Okay.
Yep, we got that.
All
Okay.
right. Last one.
And safety standards, yep.
Last one, I want to make sure that there's specific language that says that the applicant has to, I know I heard something that said something to the effect of, you have to demonstrate ownership of the access road, but I want to make sure that given the fact that there is a lawsuit that's currently pending on this issue, that the applicant demonstrate that with an order of the court, that it actually has the right, the legal right to use this access road. And that should be a condition of approval, I think.
I'm not sure I agree with
Well,
that.
right now, the language we have is just to identify the ownership of the proposed access road between 18 and 23 Autumn Circle and the rights of others for its use. What's not stated is that the applicant has to demonstrate that they have the right to use it.
That they have the legal right to use it.
So I think I would go so far as to say nothing in our conditions or in the permit indicates this board's agreement that they have the ownership or rights to use that way. But it will be up to the, either your lawsuit in court or someone else if it's contested. But I think it'd be unusual for this board to require an applicant to get a court order saying they have the rights to ownership of a parcel of land or to go across a road. That really seems out of the ordinary to me. Susan, what's your?
Yeah, I mean, I understand the concern and the sentiment. I think the fact of the matter is that just because a board grants a permit to build something shown on a plan, if someone, it's established that they don't have the legal right to do it, this permit is not going to give them that right to do it.
But-
And I don't know if you want a statement in here that says that, I don't think you need to, but I think, if you want to put in a statement that the granting of this permit does not, the
Right.
approval of this project does not grant any rights that,
Right,
for
right.
construction of this,
Or-
that the
Or
board-
acknowledge the board's view that they have those rights.
right.
But in fact, it's a condition that they have the access. So if they were to go out and...
It's predicated on it.
Right, right,
Yep.
they could purchase it rather than going to court, then there'd be no reason to have a provision here that required they went to court.
Okay.
But-
I think that's
yeah.
fair. Yeah,
So-
that's kind of what I'm getting at,
Yeah.
is I don't want to create any expectation that by virtue of the grant of this comprehensive permit, somehow anybody has the right to go on any property and put a road in.
Right,
Do you want a sentence to that effect
Yes.
added?
yeah, as I discussed, and...
I think that's reasonable.
Yeah, and quite frankly, the applicant's view is going to be nothing in their permit says that they don't have the right.
Right.
So we are not, nothing in our permit will acknowledge whether or not they have that right.
Thanks.
So can I just walk back through those real quickly? So to ask the board which ones, if any, of Jeff's requests. The first one he requested was that the Autumn Circle access road be 24 feet in width with a sidewalk on one side consistent with the internal roadways.
Now, is that, do we have something from...
So, no, we have a no man's land, so thank you for pointing this out, where we focus a lot of attention on the cul-de-sac and then Autumn Circle itself extending to High Street, as well as the internal roadways, but we didn't focus heavily on the Autumn Circle access road, so I think it would be appropriate that the same standards that apply to the internal project roadways and the public way continue for that stretch in between.
And I tell you, otherwise you have a situation, and Pat could speak to this better than I could, obviously, that the permit's requiring 24 feet for the internal road, so what happens when you hit the access road? I guess is the
You have a
question.
bottleneck, or are you going to, right?
Yeah, I think it's, with the other, if you're going to require the other roads to be 24 feet, then that section of the road on Autumn Circle should also be 24 feet. I think that's reasonable.
Yeah, I mean, I actually measured Autumn Circle in a few spots, and I got 20 feet driving, and then there was a couple of small Cape Cod berms, so I think one of the engineers said that it was 24 feet wide, but driving up and down, it seemed narrow to me, so I just wanted to measure it myself. So it isn't quite 24 feet wide right now, so.
Okay, so I think you've got agreement, Susan, on the first one?
And then the second one he mentioned was,
Let's make sure she's
Oh.
with you on this.
That's not the road.
Okay, Susan, we're going to the next one?
Yep, the second one, the snow storage, I believe is already.
no, can we get to
sorry.
finish the rest of the standards for the access road? You also mentioned a sidewalk, so 24-foot width
With a
plus a
sidewalk.
5-foot sidewalk, because otherwise it,
Well, right, consistent
wouldn't.
with the internal roadways.
so granite curb, underground utilities.
Well, wait, I'm going to go through in the order that he listed them.
Okay, I'm sorry, I thought I did that too.
Nope, that's okay. So his first one was the 24-foot width with the sidewalk on one side, consistent with the internal roadways. That would be a proposed condition. The next one that Jeff listed was no storage along the Autumn Circle access road.
And we've
I
got the
think we've
same
already
safety
got that.
issues and
But is
access.
that already covered by a condition?
Item F4 on page
Okay.
16.
Yep.
So that one's covered.
Well, wait, let me just, page 16, sorry.
Right there on the last line.
Yep. No snow shall be removed from the project onto adjoining properties, including Autumn Circle, but this is removed from the project to Autumn Circle.
Right.
But he's going
Yep.
beyond that,
Yep.
so it's not covered.
Okay. So would the board like to add a condition?
Yeah, I mean, if it's going to be a reasonable access road, then we need to have that condition.
Right. Is the concern that the snow would be plowed then onto the two properties on either side of the access road? Is that the concern?
It kind of goes a little beyond that insofar as, since we know that there's no affirmative grant of an easement, the issue is whether anybody even has the right to store snow on this particular way. I'm not sure that even if the way exists to the benefit of the applicant, that that's even something that is able to be done. And so you have that issue, and then you have the issue, very, very astutely stated, I'm very concerned about just pushing snow on someone else's property. And so I think that, I'm concerned about that more than I am.
So snow on from Autumn Circle shall be removed by the applicant onto either its own property in a way that does not interfere with site use, site access, and shall not be moved on to other private property. That's what I think that's what you're asking for.
Do we need to say that the applicant is responsible for snow removal from the access road? Because
At some point, this
It's-
could
I
be
mean,
a
we're-
public street.
No, it's not.
no, this is all
Oh.
private after the end of the cul-de-sac. So we say that the applicant shall remove snow from the site.
Right.
And should we also add, and the Autumn Circle access road?
Which one is that? Is
Yeah.
that?
We're in F4.
Yep.
Yeah.
So, right, the applicant shall remove snow from the site and the Autumn Circle access road as practicable, as soon as practicable, following large snow events when the site or the access road cannot itself accommodate so storage without a loss of driving aisles. No snow shall be removed from the project or the Autumn access road onto any adjoining properties, including Autumn Circle access road, or Ward Street, or, I guess we've already covered the private
Yep.
properties. Okay, so that's, I think, the point you're making.
Okay, so that was the second one, that was snow. The third one was the subsurface utilities only. We talked about drainage. Here's a question, I don't know, Pat, if this has been covered, and I apologize if I missed it because I'm not focusing on the details of the review, but because the town, as part of its taking of the layout of Autumn Circle, also took a drainage easement in this 20-foot way, is the town currently using that easement, and is there anything in their proposed subsurface drainage that interferes with the town's existing subsurface drainage easement? Is the town's subsurface drainage easement shown on their plans in any of the?
No, it's not shown on your plans.
No, it's not, on the existing conditions plan, they just show the way, or the, whatever it's called.
Okay, so-
But there's no utility shown in
No
it.
specification, really,
Okay, so,
whatsoever.
I mean, I think this is a concern, of course, now, speaking as counsel to the town.
Right.
The town has taken an easement for drainage through that area. I think that for that not to be, that should be shown on the plan, added to something that's shown on the plans, and there needs to be a determination that their construction of the way and their construction of any subsurface drainage does not interfere with or encroach on the town's easement.
Yes. So where would you place that as a condition?
Well, I think that the showing it on the plans should be in, what is that section, is that, Emily, C1?
Well, so if we do it all under the Autumn Circle access road and related
Oh,
improvements,
okay,
would that
yep,
work in
yep, that
section
works,
3?
that's
So
still,
we've got
that's still
the-
under C?
Yeah,
Okay.
the identify the ownership of the access road, and then we could add either underneath that or as part of that, as well as the drainage easement over the access road.
I might add it as a B, and then rename the other, re-letter the other ones going down.
Yep.
Okay, so show existing town drainage easement per Autumn Circle layout, and I'll be very specific about that.
Right.
And then, is there some sort, where would we speak to, they can't encroach on or interfere with, any proposed subsurface drainage cannot encroach upon or interfere with the town's existing drainage easement? I guess, just put it in the same condition?
Yes.
I also noticed that there's a marking on the plan that says, Pat, you might be able to help with this. It says proposed gravity sewer. seems to be in this location, and I'm not sure what that means.
It's pointing over here.
Okay, because my plan is so small.
Okay, so anyway, that was a diversion, sorry, but it was important, so I'm glad it came up. With respect to any utilities in there, are you just limiting it to subsurface for any utilities, or just limiting it to subsurface drainage as shown on?
Well, there are no utilities shown.
Right.
That are not subsurface.
Right.
So I think that's an appropriate condition to add, because there's going to be visual issues.
Right. But do you want to limit it to just the, and maybe this can all be incorporated into the new B, that only subsurface, that they have to locate the town's easement, and only subsurface drainage is permitted, that's the only utility permitted, and only to the extent it doesn't encroach or interfere with the
Right,
town's.
and that
So
is-
incorporate it all into one.
Correct, especially since that's the only thing that they've shown on the plan. Yeah. Because if they're considering something else that's not on the plan, it may raise
Okay,
open space issues, health issues, safety issues, so we can't even address them.
okay, so that was the subsurface drainage. The next one was that the Autumn Circle Access Road shall not interfere with, I believe you said driveways, or was it access generally to abutting, the properties abutting the access road?
That's right. There currently are driveways out
Yeah,
there, right?
so no interference with driveways to the abutting existing driveways? Like, what's the proposed condition?
I think that the proposed condition should be, shall not interfere with the presently existing driveways and improvements at 18 and 23 Autumn Circle.
So the issue, and I want to make sure that we're clear on it, is if there's a situation where an existing driveway goes beyond what the current owner is lawfully entitled, they've encroached on town property, for example, we're not grandfathering that through this condition. So it's not the existing driveways, it's the...
Is it access to the, I mean, I understand what they're asking. They want a condition that would not allow them to put a road over Ms. Bethany's existing driveway.
Right.
I guess the
As long as that
question for the
driveway is a
board
lawful driveway, then it's
becomes,
fine.
right, I guess the question for the board is that putting you in a situation of determining that they don't have that right, that a court wouldn't tell Ms. Bethany she has to move her driveway if they've established rights? And I guess, are we somehow stepping on something a court's going to determine? I just don't want the board to step into, right.
Be construed so as to require Miss Bethany to do anything with her driveway. She shouldn't have, just because somebody has applied for a comprehensive permit, doesn't mean that she should have to move her driveway.
Right, you don't
And-
want the
and-
board to tell her that, but for the sake of argument,
I think that
just,
the board should tell the applicant not to interfere with her driveway.
No, and that's what I'm saying, is
Yeah,
we
if
would
it's
not
law.
take that.
Right.
So to the extent, I mean, just take, I have no idea about boundaries for the property. If she has a current driveway that goes beyond her boundaries, are you asking us to tell the applicant to respect her unlawful driveway? Is that what you're requesting?
No.
Okay, so it
You
would
could
be
say
limited to...
Within her
Within her property,
property.
right.
okay,
I think-
the question I have, and I'm sorry, I just need to play devil's advocate to be consistent with the statement Joe made earlier about not playing land court. For the sake of argument,
Right.
if a court were to find that the applicant has the right to build this road,
Right.
and that would require Ms. Bethany to move her driveway, is the board, by this condition, therefore saying, being counter to what a court might otherwise order, and saying, notwithstanding the fact that the court said they have the right to put the road through her driveway, this permit says she can't?
No, because the
Okay.
court has plenary power to
Right.
order what it orders, right?
Right.
So,
But do you see what I'm
I
saying, Joe?
understand what- I
Okay.
understand what
So
you're saying.
listen, I'm not taking sides here at all. What I'm trying to do is not have the
Protecting the board.
board.
I got it.
Yeah, okay.
So I...
And can I just show you something on the
Sure.
plans, just to try to clarify something?
Hey, Joe, would you hit the override button on the, thank you.
So this is her existing driveway, and the road goes through.
Thank you.
So that's what they're talking about.
They're proposing to relocate
This
it.
right here, these two lines are coming up with the cul-de-sac.
Right.
So with the roadway, they are interfering. If the roadway is constructed like that, they will be interfering with that driveway.
I'm not sure that they've actually, I don't think that they've surveyed this. I think that this is an approximation, but
Yeah.
But I just wanted to point that out, that that's where that conflict is.
And the property line is the middle of the,
Right.
okay, so you got 20 feet here and 20 feet there.
You can see the driveway here.
Okay, so I think what I'm hearing is a request that the board make explicit that nothing in our permit would be construed as authorizing or requiring, as authorizing the applicant to engage in any activity that would interfere with a private property owner's property rights.
Yes.
And that's,
If you want to make that statement, that,
yeah, I think that's,
it's a softer way of saying what we're trying to accomplish.
Susan, are you comfortable with that? Because I think that,
Yeah.
I think that's,
Can you
that
just
gets
repeat
to what
that,
you want.
please?
Yep.
I knew you were going to say that.
Nothing in this permit shall
No-
be
no-
construed, right? Is that what
Yeah,
you said?
right, nothing in this permit shall be construed as authorizing the applicant to engage in any activity that would interfere with the property rights of abutters.
Okay, I get it.
So that might belong in a different section than this, but I will note that we distinguish between the driveways entering the roundabout, and then we don't have a standard for other driveways. So we may need to clarify that. So right now, we have 3B2 that says the roundabout.
What page are you on?
Sorry, on page 10.
Okay.
That the roundabout shall be designed so as not to inhibit access to residential properties abutting the roundabout, but maybe we need to add the Autumn Circle access road and the
3B2.
roundabout shall be designed
Right.
so as not to inhibit access to residential
Right,
properties.
so now reads, right, so the roundabout and the Autumn Circle access road shall be designed so as not to inhibit access to the residential properties abutting the roundabout or require that motors, okay, exiting driveways when they back up into the circulating area, is what you're saying.
Yeah.
But I think what I'm hearing Jeff request is that we make it clear that we are not, nothing in this permit should be construed as authorizing.
Right. I think we can add that condition that as you
Yeah.
cited it, and then also make the change Emily recommended in little 2 there, Roman
Right, so,
2.
yeah, so if it turns out that someone goes to court and the court says, hey, the applicant is in fact allowed to do this, then that would be consistent with our permit. And our permit would not be used to say, even if the court said something, our permit doesn't allow it. So I think it satisfies the concern that you were raising. Susan.
Yep. Okay. The next one was, he just wanted to confirm that all the conditions that Jeff Dirk was recommending were going to be followed. All of Jeff's recommendations have been incorporated in the decision, in the draft.
Right, but I think the concern, maybe it wasn't as expressed like this, is that to the extent that there are supplemental plans, minor modifications that come in that alter what Jeff Dirk has proposed, that would not be allowed because all of a sudden it's affecting the safety issues.
Right, but at that point, the board could make a determination that whether it was a substantial change and reopen the hearing, right? I mean, I guess if it was going to alter something that would have a negative impact on the abutters, right, the board is then asked under the regulations when the change is proposed as to whether or not it's substantial or not.
Right.
And if the board felt
Right,
it
okay.
would impact abutters or whatever, and that a public hearing was required,
Okay.
you could find it was a
I'm
substantial
fine.
change.
Okay, I agree.
Right, okay. Two means of access was covered. Then we already discussed, you wanted to demonstrate by order of a court, but we came up with alternate language to address that one.
Right.
I think those were all the bullets I wrote down as you spoke, Jeff.
One second.
The snow storage.
If you could just get up to the mic.
Yeah, that's it, though.
Okay.
That's it.
Okay, thank you. Yes, sir.
Farouk Youssef, 48 Ward Street. I did hear you say that the construction activity would be only limited to the new access road, not through Autumn Circle, and I'm assuming also not through Viking Lane. Is that correct?
Not through Autumn Circle.
No, well, there are proposed conditions that if they're going to use the access road to the cul-de-sac to make improvements such as a sidewalk, et cetera, in Autumn Circle. But they couldn't have construction vehicles coming in and out that
Right, but
way.
what about Viking Lane itself?
Yeah. Yeah, he's
Well,
asking about
I thought you said all the construction activity going to be going through the new access road. Limited to that access road only, not through Viking Lane or Autumn Circle.
So, no, I believe construction activity can go through Viking Lane.
How could be if the sight line is not proper, and has been said in the previous meeting by the council, that it's dangerous, how could you use it for construction activity? And also, I'm saying we have the right to plant on that side of the road.
Right.
So that
right.
should
So
be,
you're saying the sight lines would not allow safe...
that's correct. So construction activity should be limited only to the new site, to the new entrance that he's proposing now.
We did not address that.
No.
What's your, do you have an opinion on that?
Well, it's the board's choice, but I would guess that when they started construction, they would probably use Viking Lane as their access, because that's the access to the property now.
Right, but what appropriate sight lines would be needed so that construction equipment can go in and out in a safe manner?
That access road could be constructed first at the beginning and used as the construction from day one.
Yeah, I guess the proposed road actually goes through the 70, pretty much through the existing house at 70, so if they demoed the house first and went in that way, they could probably go that way and access the site solely through that access area.
The point you're raising is if there's a safety issue that's been raised because of
Absolutely.
Viking Lane, why does it make sense to allow construction traffic?
Which is
through
a lot
there?
worse than regular cars, in my opinion.
Yep.
Bigger vehicle cannot stop as fast, and been admitted several times the previous meeting that that road is not safe for access. And we're talking about safety here. So please make sure that's been
Right.
implemented.
About a proposed
Okay,
transportation for construction vehicles.
Mary, do you have a
Well,
thought?
existing, yeah, they're blocking off Viking Lane, so I don't see.
Which one is that?
From the beginning, from the
Right.
beginning of construction.
No, isn't, oh,
Well, I guess we can ask the applicant if you were planning on using Viking Lane for construction roads, and if so, we could actually impose a condition either to make sure the sight lines worked, and if you couldn't, then you couldn't use it. But if it may be moot, so I just don't know what your plans are.
I'm not quite sure it's moot, nor do I know the construction schedule or the methodology
Right,
of
okay.
attacking the site, so
Okay.
we're not sure about that. But I think that the issue, if anything, might be the fact that exiting that site is where the sight lines come into play, rather than maybe entering the site. So I don't know whether or not there's a distinction to it. I think that if we can establish a safety issue, it is not designed to be an operating entrance and exit when the site is up and running.
Right.
But I don't know whether when you attack the site, whether or not we need to attack it initially through to take the house out or to make that roadway accessible. That may be necessary on a limited basis. And if necessary, we could have, for example, a police detail that would be on site to make sure that there would be no issues with regard to entering and exiting off of that road. That may be a fair condition.
Yep, got it.
We're on page 2 in B3.
Yep.
So after the, I don't know, somewhere in there, before after the second sentence, right now it says construction vehicles and delivery trucks shall be prohibited from traveling on Autumn Circle, so it would be,
Or a Viking Lane.
well, I guess the question is, you know, Attorney Baker proposed some, if it's going to be used, there'll be a detail or some, I don't know which way the board wants to go with that, if at all.
Well, I mean, clearly, the Viking Lane egress is going to be, would be an issue, it would be a safety issue. But if on a short-term basis, they can address that safety issue to the satisfaction of, the question is it of the zoning administrator, of the police department, the fire department, it needs to be addressed to someone's standard.
So do you want it prohibited from Viking Lane except to the extent safety measures for egress are approved by the zoning administrator and HPD?
Yeah, I think that addresses the concern. So if they had a police officer stationed there to make sure that, you know, stop the traffic to make sure that if someone's exiting, that there's not a problem, that would be a short-term fix to the good point that you've raised.
And how about use of Viking Lane for construction vehicle access or egress is limited to the time until such time as Road C is acceptable for vehicle access, for construction vehicle access?
So if I'm correct, access is not the
I think that's the
problem?
point here,
It's
too.
the egress?
Yeah, it's exiting.
Right. Yeah, the site distance is only for exiting traffic.
And then, so prohibited, except to the extent safety measures for egress are approved by zoning administrator and HPD, and then only until Road C is available, or, I don't know, is adequate.
Suitable for use.
Suitable.
For construction access.
Well, I mean, I think what we'd hear from the applicant is, well, Road C may be working, but to get this project done efficiently, they still want to use Viking Lane, and they'll still have the officers there. Are we saying they can't do that? I mean, clearly, Viking Lane is not going to be allowed as a usable access point for the project once it's construction. But as long as they've met, you know, safety concerns the police and the fire department might raise for purposes of the construction equipment, I'm not sure why we would say they can't use it. Mario, what's your...
No, I see where you're coming. I mean, it's pretty common to have detail for access and egress from sites, so, yeah, it's not unusual. I would be okay with that.
Anything further on that?
Well, as I'm saying, it's been ruled before that's not safe to use for any time or any use, and we're letting construction equipment go in and out continuously.
Well, what we're saying is we would not allow that unless, for example, there was a police officer there who could make sure that it was done safely.
And if we see that no police activity is there and been used, who should be calling?
Well, you would call Emily and the project will be shut down.
Okay.
because that's, it will be clear that we are not allowing something that would endanger the public. Okay, thank you.
Okay.
Anyone else? That was really excellent. Thank you. Okay. So let me talk schedule and what we're planning to do. I think the game plan would be
Back in 2
that
weeks.
Emily, with the assistance of counsel, would work on getting to the applicant the waivers and the conditions in a form that reflects what we've reviewed this evening. And it would be my understanding that that could be done by close of business tomorrow?
Well, not town hall close of business, but
By your close of business?
yes, by my close of business. Sometime, I mean, assuming, Emily, unless you have a conflict, if I could touch base with you later in the afternoon, which would be after Emily's work hours, but if it's not inconvenient for her, if I could touch base with her at some point in the
Right.
afternoon and she's able to get them out, then they could get out sometime tomorrow.
Right. And then once that was, so they would get to the applicant or applicant's counsel by, 5 o'clock tomorrow, or whatever you tell me is the right time.
Some,
6, 7?
yeah, sometime tomorrow evening.
Sometime tomorrow on Friday.
Yep.
And then with the goal of giving the applicant a chance to review it and let us know, once they've seen this, based on the revised language, whether they would find these waivers and conditions acceptable or not. And given the time we've got left in this hearing, I'm thinking 2 weeks, that you would then get back to us and say, you accept these conditions and waivers or not. And if not, you would say, why not? And then we would cross that road based on your response after 2 weeks. So that's the schedule I have in mind.
I think you anticipated that when
Right,
we talked
exactly.
about before.
Right.
I think that brings us into the 16th or 17th.
Yeah.
I believe the 16th would be that
Right. That
2
would-
weeks from tomorrow.
That would be
Yesterday.
12 from yesterday. That would be 12
Yesterday.
days. If they get it tomorrow evening, then they have 12 days till the hearing
Oh.
on the 16th.
Okay. So that's, you're right, that is what we talked about, yes.
12 days with 2 weekends imposed in
Right.
12 days, so, anyway. In what form do you want us to respond? In writing, absolutely.
Well, what I'm, Susan, correct me if you think you suggest something different, but I'm thinking is that you would show up at the hearing and you would either have marked up the conditions, say, we like these 12 and we don't like these 3.
We're going to be presenting them at that meeting.
Or either you can present it, ideally, get it to us ahead of time, but given the time, you may wind up doing it at that meeting.
Okay.
Because, I understand the schedule. So, again, we wouldn't be requiring that it happen ahead of time, but I'm anticipating on the 16th that you'd say, here's what we've come up with. So, does that make sense to you, Susan, in terms of the schedule and
Yeah.
to you?
The answer is
Yeah.
fine.
Okay.
I would like to make sure that we at least get them first thing Monday morning.
Yeah, okay.
Particularly if it's a late
You're not going
Friday.
to spend your weekend on them?
I'm going to be at your office, but,
Yes, our goal is to get them turned around very quickly, so if we could get them off our desks tomorrow night, we'd probably have a better weekend, too.
Okay. Well, do you want to commit to that or not? I mean, he's graciously offering, instead of sometime on the 4th, to the morning of the 7th. Do you want to leave it that?
We're going to use diligent efforts to do it. I mean,
I know, but
that's
that's
the
not what I'm
plan.
asking.
What?
Am I going to hold you to the 4th at any time, or the morning of
Am
the 7th?
I getting fired if they don't get ready tomorrow night?
Well, just as
welcome to my world.
Exactly. So.
I know, I feel like the tables are turned, right?
So, and I think council has graciously said, get it Monday morning. So do you want me to frame it that way?
No later?
to give you?
Yeah, I'd say, let's say no later than Monday morning, but our goal is it'll be in your inbox
Okay.
tomorrow night, because I don't want to be, I have a
Okay.
lot of, unfortunately, other things I have
Of
to
course.
work on this
Okay.
weekend.
And what I can ask a favor, when an email is sent to my client, would you CC it to me? Sometimes
I
I don't
haven't
know, sometimes I don't get it for a period of time, so that would be
yes.
more efficient. Thanks.
Yeah, that's, well, I don't typically send out any of the emails, so.
Okay, so if Emily will make sure, okay.
Yeah.
So what, Joe, Mario, do you have any comments on the schedule?
No.
No. Are you available on the 16th?
It's in our calendar.
All right, I just want to make sure we're good.
Yeah, I think we're already set.
Okay, so then.
I do have one more question, if you're going forward. I held off on any comments we have, particularly, for instance, the response to Amory. I am now going to send those in. Okay.
Yes.
Okay,
Yes.
thank you.
Perfect.
Okay. So at this point,
Can I just, quick question on that. So theoretically, to the extent that this response might address some of these things that might be reflected when we come back in 2 weeks, I'm just trying to figure out how we would process
so here's
that
my.
information.
So my interpretation of what council's suggestion is, he may be sending us some information, and that information he could use to support his view that a condition was not necessary, because he's now given us a report that says, hey, guess what, something works or doesn't work. So that I would interpret what is going to be submitted by the applicant as supporting information that will support his response to the waivers and conditions that we're about to present. I mean, that we presented that you're going to respond.
I think you and I are on similar ways, but what happens is there's been a number of comments that have come in even today.
Okay.
Right? I would like to address those comments because I disagree heartily with a number of them.
Okay.
Title being one of them. But the second thing is that, and I think I've already answered, but the other issue is dealing with this. I understand that they're to agree intertwined.
Yes.
So you may see an answer, and then in the condition, see answer.
Right.
Okay? But I understand they're actually two separate things.
Yes.
Okay.
I'm just going to need to wait for Mario to come back.
That's smart. And Joe,
I'm sorry.
see, you're getting tired. So luckily, I'm glad I'm not the only one affected by the hour.
Sorry about that. You're here, aren't you? Okay. So I would, at this point, entertain a motion that this board direct the zoning administrator, with the assistance of council, to transmit to the applicant the waivers and proposed conditions as discussed by the board this evening, and to do that by no later than, let me get my calendar out again, by the morning, I'll say 10 a.m. on the 7th of May, so that the applicant has the opportunity to review the conditions and waivers and respond to the board by no later than 7 p.m., which is the hearing time, on May 16th, about whether or not they accept these conditions and waivers, and if not, why not? There's such a motion.
So moved.
I'll second that.
Any further discussion? All in favor?
Aye.
Okay, so
Can-
with then...
Okay, go ahead. Before you adjourn, I have one
Okay, so,
comment.
well, I'm about to do a motion to...
Continue?
Yes.
Okay.
So do you have some comments? before that?
No, I would just say, just because there may be other people here interested in them, that upon our distributing them to the applicant, they then become a public record, so people will be able to
Yes.
get them from Emily on Monday morning as well.
So will they be posted on the site?
Okay.
So you don't even have to come
Post
in?
them as soon as we can.
Okay, so then I would accept the motion to continue this hearing to 7 p.m. on May 16th, 2018.
So moved.
Second.
All in favor?
Aye.
We're continued. Thank you. I appreciate comments.
Well, we're not going to adjourn?
I'll accept the, anything else, Emily?
With relish.
Any motion, is there a motion?
With relish, yes. I'm so moved.
Is there a second?
We
All in
need
favor?
to talk about.
We are adjourned.
Way more.